acts. So they would have us go out there. It's never our intent to just write a ticket. If we can just get them in compliance, that's all we want. We're not trying to make it uncomfortable for them, and they're not going to jail for an expired plate. If they go to jail, because it'll most likely be because they forgot to go to court and they've got a failure to appear.
So from your perspective, it doesn't matter. You said it doesn't matter if it's a class 3 or class 4, you'll enforce what you enforce. So then it would assume that it doesn't matter if it's a primary or secondary, because you'll enforce what we think needs to be enforced.
Well, I think for fictitious plates, I would absolutely say that needs to be a primary.
I guess for this conversation, based on Senator Kavanaugh's opening, I would take fictitious plates out of the conversation that we're having.
Yeah, I mean, if you say 30 days, we would prefer that it's all consistent and everything else, but just keep in mind, even when we notify them and write them the ticket, they're getting the opportunity for a 10-day grace period to go down there and get that taken care of.
I guess I'm asking for having expired plates. Do you view it as a problem for the police force to have that as a secondary offense?
Yeah, I would say that we need to be out there enforcing that. Absolutely, because it's the reason why a lot of the reasons why they're not getting their registration taken care of is because they don't have insurance.
So do you then enforce as a primary offense having house numbers improperly displayed?
That is not against the law. I have on numerous occasions where somebody won't put their numbers on their house. I'll tell them if they have a medical emergency and time is of the essence, that fire department or emergency squad isn't going to find them in a timely manner, and it might be their undoing.
So taking this to its logical conclusion, if we're going to use this as a tool for policing and allowing people to discover potentially other crimes, which we have heard from others this afternoon, shouldn't we then make it a primary offense to not have your house number properly displayed so that the police can go into your house as a primary offense if somebody suspects some malicious activity?
We can't pull over somebody's house. We can do a search warrant on if we have probable cause.
But this would remove the need for the search warrant and probable cause if we make it a primary offense.
There's no primary offense for a house or anything else. That is just, that's beyond the scope of this bill.
I guess my question is, they're both property. Why is one a primary offense and one not?
Because the legislature has told us there are certain requirements. If you're going to be on the road, you have to have a driver's license, you have to have insurance.
Sure.
And this is just, and we have to maintain the roads.
I'm sorry. My question to you is, if they're both property, and why do the police view it as an important tool to have this be a primary offense, but not this?
But if you're talking about the fictitious plates portion.
I am not.
Okay. If you're just talking about what the fee should be, my personal view is I don't care. I don't care if it's a $10 fine or if it's a $35 fine. And no matter what, when that law enforcement officer decides to make a traffic stop, they still have the discretion to decide whether or not they're even going to issue a ticket, because somebody may come up to them and say, oh my gosh, I forgot.
Right.
They may give them a fix-it ticket or something like that, or just a verbal warning, just saying, hey, you forgot? Okay, fine, here you go.
Sure.
But there may be other issues that are going on. It's like, I can't look beyond this.
I was trying to get to, and I think I understand, but we will be having to decide if we think that it should be a primary or secondary offense, and also if it's what class of misdemeanor it is. And so I wanted to make sure we were making an informed decision on how that would impact your work and what the thought process is for that.
Our organization would recommend that you maintain it as a primary offense when it comes to enforcement. And when it comes time to what the penalties will be, absolutely, that's up to you.
Okay, thank you.
Thank you, Senator Kavanaugh. Senator Moore.
Thank you, Senator Friesen. I just wanted to clarify, because I'm wanting to make sure that I'm understanding your testimony. The fictitious plates is when you take something off of one car and put it on a different car. When you're saying so with respect to that, I don't think that's covered by the bill, is my understanding, at all.
It's on the second page here, when they talk about fictitious plates.
That's what-
That, I believe Senator Kavanaugh, John Kavanaugh is going to maybe make some amendments to that portion.
I think,
But that's,
no, I think what I understood is that he inadvertently got rid of the grace period for that, but that he didn't actually touch that portion of fictitious plates. I think what he's referring to, and maybe this is just a semantics thing,
Okay.
is the expired plates as opposed to fictitious plates. So I'm just wanting to
well,
make
there,
sure.
in here, the way that I'm reading, it, unless there's, I'm sure there's plenty of other people here who are a lot smarter than I. The way I'm reading this, fictitious plates or altered plates is a secondary violation under this current,
Okay, well,
current statute.
let me just ask then your opinion so I can
Sure.
make sure I've got it. So with respect to fictitious plates, which is taking one plate from one car and putting on another, or, I don't know, inventing a plate, I don't know how you do that, then it's the position that you are coming forward that you don't want to make that a secondary offense, correct?
Correct, yeah.
Now, with respect to expired plates or, overdue plates, and with respect to whether or not that should be a secondary offense, what's your opinion on that one?
I'd be very careful going beyond, personally, I'd like to just see it the way that it is, because people are going to complain saying, if I have to pay the taxes, why don't they?
Sure.
So that's, you will tell us how you want to enforce these rules, but just to be consistent with everything else, we would prefer that it would remain a primary offense.
Okay, I just wanted to be sure that I understood your testimony because I was trying to follow fictitious and not fictitious.
Yeah.
Thank you.
You bet.
Thank you, Senator Moore. Any other questions from the committee? So the one real simple solution is get tags on your car and you won't get stopped.
Correct.
And you're saying a lot of the driver for not having renewed plates is probably because they couldn't afford the insurance. Now they just couldn't license their plate because they couldn't provide proof of insurance.
Correct.
Okay.
I missed my chance.
Senator Moser.
Thanks. You wouldn't know if plates are fictitious unless you ran them, right?
Correct.
So you would have to have some reason. I mean, you wouldn't just go watching every plate that goes by and call in dispatch and ask them if this plate matches this car.
Yeah, I generally don't have that much time to run every plate. Now, there will be times where it might be a little slow and you're just checking to see if certain cars are stolen or anything else, because we get a lot of complaints saying, hey, in this area, we've had a lot of stolen cars. And we will also get complaints about the fictitious plates. People in Omaha, sometimes we've had a run where they will steal the stickers to try and trick us, saying, well, that car is supposed to be registered or expired in June, and that tag says December. So it's just always a game. And there are times, sure, we're just running plates, but generally it's for a reason.
So sometimes they'll peel the sticker off of another plate and put it on theirs.
Oh, yeah.
I can't
Yes.
even get them to stick to my.
I know, but it has been an issue in the Omaha, Douglas County area.
Thank you.
Thank you, Senator Moser. Seeing no other questions, thank you.
Thank you very much.
Mr. McGuire. Any others wish to testify in opposition to LB 934? Seeing none, anyone wish to testify in a neutral capacity? Seeing none, we have one letter in opposition and one in neutral capacity. Senator Kavanaugh.
Thank
may
you,
close.
Chairman Friesen, and thank you, Transportation and Telecommunications Committee. I do appreciate the robust conversation we're having here today. And I do want to clarify for the record, Officer McGuire, obviously I have tremendous respect for him, and he and I get along a great deal and have worked together in the past. And so I appreciate him coming down here and testifying even when it's against me. But just to clarify, the way the statute's written, we bifurcated that fictitious plate, which actually, Senator Mosher, your example there would also be a fictitious plate, taking the tag off another car and putting it on there. We bifurcated that, and that created a new subsection, that is subsection 4, and then the section is, the secondary offense is just, it says just making section 2 and 3 a secondary offense, and section 4 would remain a primary offense. So that's why the fictitious plate would still be a primary offense, whereas the expired plate would be a secondary offense. But just kind of points that came up while people were talking or while other people were giving their testimony. It is, Senator Geis was correct. It is a $500 fine. I believe that was what I said in my testimony, unless I misspoke. But, and then Mr. Eichholt, I think, did a great job of talking about kind of that part where we are saying the culpability or the responsibility for this action should be treated differently. If you are purposely taking the tags off somebody else's car and putting it on your car, or taking a plate off another car, that should be treated differently than forgetting or failing to pay. And so that is the nature of changing the level of the offense and bifurcating there. And then, so it's kind of two justifications, two reasons why I made these changes in this bill, but they apply to the same thing. And then the other is that making it a secondary offense, which goes exactly to, this just doesn't need to be done by law enforcement as a traffic stop. So there was some reference to going to cars parked on the street and things like that. You could still ticket a non-moving car. It just would not be a reason to initiate a traffic stop. It still would be enforceable, still would be able to ticket just like a parking ticket or something like that, but it is not be a reason to pull somebody over and stop them while driving. And again, Ms. Weber was testifying, and of course I have worked with many of our county attorneys in this state and have respect for their opinion and perspective on things. But I disagree, and that's the reason for this bill, that the justification for a primary offense stop for a license plate is that they will discover other evidence as to other crimes. It's not, we shouldn't criminalize behavior because we think it'll help us solve other things that we want to investigate. And that's kind of the reason that the stick, I guess the sticky wicket or whatever you want to call it, the problem in this conversation is, it is a convenience factor for law enforcement to get a search, a pretextual search, to get other evidence and find other crimes. But that's not a good enough reason for that to be the law. And that is the reason that I propose this change here today. And then as to whether or not you can discover stolen vehicles, if a vehicle is reported stolen, that they run the license plate and that'll tell you that vehicle is stolen. And Senator Mosher, I think you're probably remembering older movies. They don't call like radio in. They have like a little computer there. And I was hoping that Mr. Officer McGuire would get to that. They kind of, when I've watched Cruiser Cam, and I've watched quite a few of them, not as many as I'm sure he has participated in, but the officers can lean over and type on a little computer that's kind of in the front shotgun seat or whatever you want to call it, and run the license plate. And then that will tell you, one, whether it's expired when it has that other tag on it. If they have the wrong tag, as Officer McGuire pointed out, that'll still tell them that they didn't actually renew it, or it'll tell them whether it's been reported stolen, or they'll tell them if it belongs to a different type of car. And so that's where all that information comes from. And they can run a license plate of a car in front of them at a stoplight or one that drives by. They can do it pretty quickly. And so just because if we took away the ability to make it a primary stop, that doesn't mean they aren't going to run plates. And that's a distinction, I think, that's important. So I appreciate everybody's time here, and I think this was a really good conversation. And I'll take any other questions that are left.
Thank you, Senator Kavanaugh. Any questions from the committee? Seeing none, we'll close the hearing on LB 934. And we will open the hearing on LB 731.
You ready for me?
Yes, go ahead and begin.
Okay. Good afternoon, Chairman Friesen and members of the Transportation and Telecommunications Committee. My name is John Kavanaugh, John Cavanaughh, and I represent the 9th Legislative District in Midtown Omaha. I'm here today to introduce LB 731, which would amend the Small Wireless Facilities Placement Act to provide certain requirements for the placement of facilities and the installation of modification of utility poles. I brought LB 734 in response to a constituent concern that occurred last summer. When a wireless provider placed a utility pole directly in the middle of a sidewalk outside of a residence near 55th and Poppleton in Omaha. I had a number of conversations with the city officials and constituents about this particular site, and we agreed that a change in law was necessary to prevent this sort of thing from happening again. First, LB 731 provides that a political subdivision may require reasonable notification to adjacent property owners prior to installation of a small wireless facility. This requirement is permissive and not mandatory. Understanding the variety of political subdivisions that are subject to this act, we know that what works for Omaha may not work the same as it works in Henderson. Second, LB 731 provides that prior to the installation or modification of a utility pole, a political subdivision shall require that the wireless provider certify that the installation complies with the Americans with Disabilities Act and relevant regulations. This does not obstruct or hinder usual travel of public safety on such right-of-way, and does not obstruct the legal use of such right-of-way by any utility or impede the safe operation of such utility system or provisions of its services. The wireless companies will say that both of these provisions are unnecessary, that it will provide unnecessary delay, but also that it is already within the city's discretionary authority to do so. But in numerous conversations with the city of Omaha, they have made clear to me that they feel they have little authority to reject any installation of wireless facilities, even those that fail to notify property owners or, as in the case of the pole in my district, place a pole in the middle of a sidewalk. The certification requirement puts both the political subdivision and the wireless provider on notice that these are not discretionary requirements. They are a necessary component of any plan, and they ought to be a necessary component of any plan from the beginning. Let me stress again, in particular, that compliance with the Americans with Disabilities Act should not be a discretionary requirement. I have spent a lot of time on this issue in the last several months, and while I believe the city could have done more to come up with an alternative, I also believe them when they tell me that they believe their hands are tied by the current state of the law. They don't feel that they have the authority to reject any egregious examples such as this. This bill is not meant to require anything of a wireless company that they should not already be doing as good corporate citizens, notifying property owners or residents before they tear apart a sidewalk in front of their home or dig up their yard. Ensure that when you place a pole, you aren't obstructing traffic or making it impossible for those with disabilities to use the sidewalk. If you've seen these plans for small wireless facilities, you know that they are incredibly detailed and precise about the need for each location to be exactly where it is. All we are asking is for at least a fraction of the same attention to detail to be devoted to the neighborhoods and communities that the wireless companies say these poles are intended to serve. I thank the committee for your time, and I'd ask for you to advance LB 731. I'd be happy to take any questions.
Thank you, Senator Kavanaugh. Any questions from the committee? Senator Moser.
Typically, sidewalks are on the right-of-way.
Yes.
So why would the city allow them to put a pole in the middle of a sidewalk on the right-of-way? It's a city property. They should be in control of it.
Well, that is specifically allowed in the previous iteration that this bill is amending a statute that was enacted by this body 2 years ago, I think, that said that the city has limited discretion to deny placing those poles in the right of way.
You would surely think that limited discretion would cover putting the pole in the middle of a sidewalk.
I generally would agree with that.
Wouldn't there be an ADA committee in Omaha too that would address this?
Well, this, and maybe it'd be better for my closing because my city councilman's here and he's going to present you with the pictures, I think, of what happened. I could talk about it then. But the reason for that ADA part that I brought in this bill specifically has to do with how this went down, where the city approved putting the pole in the middle of the sidewalk with the intention of curving the sidewalk around to the south. And then once the ADA review was done, after the sidewalk was torn up and the pole was put in, they discovered that would not be ADA compliant and the sidewalk needed to go to the north. And so what I'm saying is they have to make that decision about where the sidewalk's going to go before they place the pole. That's what I'm asking to be done here, so that we don't get into that sort of situation. So they did consider ADA, they just considered it poorly.
Okay, thank you.
Thank you, Senator Moser. Would you agree that if there would have been two adults standing there, this would have never happened?
Well, I can tell you if the two adults were myself and Councilman Begley, it certainly would have happened. But we didn't find out until the pole was already in the street
I mean, it was like two kids arguing over a candy bar.
It's not a good look.
You're asking this body now to settle a dispute that should have never happened.
Well, I'm asking the body to just put a little bit more teeth in the ADA requirement and the notice requirement.
Anybody with common sense would have never let this happen, ever. Thank you.
Thank you.
Proponents, LB 731.
Good afternoon, Senator Friesen. My name is Danny Begley, D-A-N-N-Y-B-E-G-L-E-Y, and I am the proud Omaha City Council representative for District 3. It's great to be here today. As I look around, I see a couple friends, Senator DeBoer, and if John left, my favorite Senator Kavanaugh Michaela. Good to see you today. Committee members, it's my honor to be here today in support of LB 731, introduced by my good friend and my state senator, John Kavanaugh, and co-sponsored by Senator Hunt on behalf of the city of Omaha. So those pictures that are going around today that speak a lot of words to the two that are there, I'll paint the picture. By July 1st, 2021, I was fresh into my first month being elected to the Omaha City Council, and the fire hose that I'm drinking out of is going pretty fast still, as I'm learning my new job, as all you have, being newly elected at one time or another in your careers. I got a text message from a constituent showing, advising that the corner of 55th and Poppleton had a pole in the middle of the sidewalk. So of curious nature, I drove up there myself and spoke to the property owner that lived there by the name of Jane. And I called my friend Senator Kavanaugh, and we both went back later on to speak to the constituent. You see before you a picture of the unintended consequence of the original bill, LB 184, that was passed and signed by Governor Ricketts in 2018. The purpose of LB 731 is to have communication companies who are providing the tools for all of us to communicate. Constituents and property owners, when these poles are going to be installed, should have some notification of the installment instead of getting home and seeing a backhoe in their front yard. Having a name and a contact person to call should be a simple requirement. This by no means is a criticism of the original bill, which was well intended and necessary to enable our citizens to enjoy the cutting edge technology that all of our kids are always telling their parents about, like myself. And then the ever growing workforce that is working from home. This is a tool that enables people, especially during the pandemic, as well as students that are studying at home, that can use this technology. Transparency and communication by the communication companies is what I'm asking for today. And if you think of a good marketing slogan, communication companies that are providing communication should communicate to people when they're putting poles up, whether it's in the middle of a sidewalk or in other places. Again, I appreciate being here today, as I know you have a full schedule. And I again ask for your support of LB 731, and I will be happy to try and answer any questions.
Thank you for your testimony. Have you ever heard of the phrase, "you can't fix stupid"?
I have.
Any questions from the committee? Senator Moser.
Does the right-of-way end right where this pole is?
So if Senator Friesen, or I'm sorry, Senator Moser, if you look at this picture, I'll just kind of give you a little backdrop on what we're looking at here. So the pole in the middle of the sidewalk, to the right of that, between the curb where the grass is there. In a perfect world, you can't fix stupid, Senator Friesen, you're right. The reason they didn't put the pole there is because there's a water line running right in the street there. So they couldn't put the pole on that side of the sidewalk. They couldn't put it on this side, which is in the property of the homeowner, Jane, that lives there, because there was some telecommunication lines running there. So you think, hey, why not put it on the corner, which I'm sorry I don't have that. If you look at the other picture, right on the other side, you see the overhead power lines there. There's an OPBD power pole, and they couldn't put it on there either. And as one of the many things I've learned during this great month into my city council seat, a radio frequency engineer with Verizon, they thought about putting it on the east end of the property, which is the far side of this picture, on the other side of the property. But the radio frequency engineer with Verizon, who I got no reason not to believe, said it'll do something with the signal that it won't be a receptive signal. So back to your phrase, you can't fix stupid, and the right-of-way issue, Senator Moser, it was just like the perfect storm of there was no good place to put it. So then they put it in the middle of the sidewalk because that bill passed a couple years ago, allowed it. And then they couldn't put the sidewalk on this side of the, to the parking, to the sidewalk because the ADA issues arose. So they ended up swinging it to the north side of this, so it's ADA compliant. So it met the requirements that were under the law, but I think the intent of LB 731 for communication companies to communicate would be that they go knock on the door or they give the notification. So Jane, the homeowner, or adjacent property owners have a contact communication person at Verizon or wherever. And the Verizon folks, by the way, were really good. They met with us at the city and we worked through a process with them with the ordinance we passed. But for me, it's about communication.
Well, you're getting back into more testimony here. How would notification change anything here? If this is the only place it can go, it's going to go there anyway. You're just going to make another hoop for the communication companies to jump through, and then it's still going to wind up in the middle of the sidewalk.
Fair point, Senator Moser, but I believe that it's not a hoop, but it's good government. It's good communication. It's if a property owner gets home like happened here, there's a backhoe in her yard digging this up. And to me, having a contact person.
But it's not in her yard, it's in city right away.
Correct.
Okay.
But as a property owner, you're thinking they would like to
You
have.
think it's your property even though it's not.
Exactly right.
Now, what's the spacing of these small cell towers supposed to be? Aren't they supposed to be half a mile apart or something?
I'm not sure what the proper spacing is, but it was this corner they couldn't, there was on the back end of the property, like I said, they didn't want to put it there because of the radio frequency. The corner where the OPPD power pole was, they couldn't put it there. So this was the only space that they told us it could be placed.
Okay, thank you.
You're
Thank you,
welcome.
Senator Moser. Thank you. Senator Bohr first, and Senator Hughes.
So where is the pole? What does it look like now?
It looks right like this in that big picture
Uh-huh.
that you have the far away. That's what it looks like now.
But the sidewalk is to the,
The sidewalk is, yes,
outside?
that's exactly right. It goes around it, so it's got a curb around it. It meets the ADA requirements.
and ostensibly that is the property owner's area where the sidewalk goes into now?
It goes into her yard now. That's correct. And the city does have the right of way going on that part. That's a good point, Senator DeBoer. The city of Omaha, they told me, does have the right of way on that side in her property, if you can see that. But they didn't want to infringe going into her yard because it's just that woman that lives there. It was her mom and dad's house that she bought and lived there her whole life. It was just the less of all evils would be putting it where they did and wrapping that sidewalk around it.
So I'm sorry, so the city does have a right of way in that area where the sidewalk now is?
That's correct.
Okay, so theoretically, let's say, they could have put the pole and, a few inches to the left or a few inches a foot, whatever it would be, and then left the sidewalk the way it was, but then it would be just this pole all of a sudden grows up in her yard. Is that right?
I think based on what I was told and everything I've learned in this, Senator DeBoer, I don't think they couldn't have put it any closer to the street because of the water main that's running there.
Right.
So it could have been maybe 6 inches or a foot to the north, which is towards her house. But that is where the permit was issued and the sidewalk got wrapped around it after it, so.
Do you have others in your area of the city? I haven't noticed them in my area of the city, but do you have others in your area of the city where they're just sort of small cells on poles that are kind of out on their own and not attached to some other already existing pole?
Yeah, they have placed many of these around Senator DuBois in the last several weeks. Most of them aren't like this. Some of them, they will pull out an OPBD pole and put this pole in there with the OPBD street light on it, is my understanding.
Okay. Have you seen others where it's just the small cell?
There are some, yes.
Okay, that's interesting. Thank
Yeah,
you.
You're welcome.
Helpful.
Thank you, Senator DeBoer. Senator Hughes?
Thank you for coming in today. I guess my question's simple, and I'm kind of in the Senator Friesen camp on this. Did anybody get fired over this? Somebody should have.
I don't believe.
Absolutely.
I don't believe Senator Hughes, anyone was fired. I think and again, I'm not a lawyer like a lot of smart people are, including my friend Senator Kavanaugh that introduced the bill, but it was my understanding that under the law and the restrictions under it, my understanding was they couldn't deny putting the pole in there based on the state law, and Senator Kavanaugh can clean that up for me. But in the answer to your question, nobody was fired. I wouldn't want anyone fired for this. I just want an education process where property owners know they have somebody to call instead of the council member, fair point, to get a call a month into his job. And I was in disbelief when somebody told me this was there. I went and looked. It's the craziest thing you ever saw.
Well, clearly, I've sat on this committee long enough, and we've had serious battles between telecommunication providers and cities jealously guarding their right-of-way. And I cannot believe that a communications company would have planted this pole if somebody from the city hadn't okayed it. But I mean, this is just beyond stupid, and I certainly don't think it rises to the level of the state legislature passing a law to fix that. Thank you for coming today.
Thank you. You're welcome.
Thank you, Senator Hughes. Any other questions, Senator Kavanaugh?
Thank you. Thank you for being here. I'm just trying to pull up the documents from 184. That was my freshman year. And I guess I would argue it is our responsibility to fix it because we passed that bill that required that. And I wasn't able to get to it fast enough to see what the city's opposition was, but I believe it was similar to what happened, which is the city's municipalities believe they didn't have the authority to stop something like this from happening, which is what the testimony was in 2019. And now you're coming back and asking us to give you that authority back, correct?
That's correct, Senator Kavanaugh. And I believe the unintended consequence of that bill, if it's corrected, this wouldn't happen. And it would be notifying property owners so they could talk to their Verizon representative or whoever, at least to have the dialogue of good communication on what's going on. And does it stop, and a fair question that I've been asked, does that stop the pole from going up? And the answer is no. But what it does, it allows the communication company to meet with the property owner and answer the questions. I think that's just fair and good government. I really believe that.
Thank you.
Thank you.
Thank you, Senator Kavanaugh. Senator Bosselman.
Yeah, thank you. Chairman Friesen, my question is, if you put a water line down that road, if you put a telephone line down that road, if you put a power line down that road, in that right of way, is that on all those, every one of those examples, is the property owner notified?
When there's a one-call ticket made,
If they're gonna run a water line, where you said there's a water line running right down through here, are they called, that property owner called and told who has it and knows?
I can tell you, the Omaha Public Power District, when they're doing cable replacement, they do have an outreach to customers that are impacted by underground cable replacements. I can't speak for the other utilities.
MUD?
But other than I think the notification is if you see a blue flag or a yellow flag or paint, red flag, orange, that's the notification process for one call that signifies there's going to be excavation. Now, whether or not to your direct question, I know OPBD notifies when there's cable replacement. I don't know what the processes are for other utilities. I don't.
Yeah, I guess my comment is, and I appreciate what Senator John Kavanaugh's bill is, what he's trying to get, but to me, it seems like there's a simple solution that is within the city itself. That you have it's in your checklist or whatever, when there's an application, this is just a part of that process. It seems to me that if someone within the city, it's your right of way, there should be something there just like the rest of them, because I'm not so sure that every time someone works in that right of way, that property owner is going to be notified. And if we do this, if we have it as part of that, no matter which one of those, if it's part of that process, I'm trying to find a solution, if you will, or to something here. If it's in that process that the city has is to notify, does it comply or not? You wouldn't have a pole in the middle of the sidewalk. So just a comment.
So thank you.
Thank you, Senator Bossman. Senator Albright.
I hate to belabor this, but whether we made a state law or not, city ordinances tell you what you can and can't do. Even if you made that sidewalk go around this, I hope they have major liability, because I'm telling you, if a kid's riding his bike down that sidewalk and it's at night, and I don't see a light on that corner in these pictures, but you could just run right into that pole. Why would you not just tell them to take it out and move it? Why is this pole so important to that neighborhood? Is it new? Is it for phones and internet? What is that pole?
It was just for the 5G Verizon. Yeah,
And they couldn't hang that anywhere else in that neighborhood, but to put it in the middle of a sidewalk?
Senator, great question. And I was in disbelief when I saw it there. And the answer I was told, the radio frequency engineer with Verizon, that was the only place at that location on 55th and Poppleton that they could put that pole. In order to have these, whatever voodoo these things do on 5G bouncing off these poles, I asked that question July 1st when I got there. And I would have loved to have grabbed a chain and put it on my bumper and yanked that out and solved the problem, but that wasn't any option that I could do.
So I should still consider it, but I appreciate you going to all this work.
Thank you.
Thank you, Senator Albright. So you were told that the city couldn't do anything about permitting that pole there.
That was my understanding based on the statute, that we could not deny Verizon from putting that pole in.
And I will disagree with that statement, and maybe somebody can clear that up, but they have the ability to deny any pole. And again, if somebody planted a flag there, even the solution, I've got a picture of it here. If I was the homeowner there, I wouldn't be happy with this either. There's got to be a better fix. And it goes back to the city and the telecommunications working with each other. And I know we fought long and hard for cell phones here, and I still think there's I'll call it a pissing match between the two. And somebody better get it cleared up, because I don't think it's our responsibility. And I think we worked long and hard to work on these pole placements. And so I guess I would like some clarity from you if you want to check back.
Sure.
I would appreciate you checking more in depth in this, because I think both parties are very responsible here. And there are alternatives, I think, because I wouldn't be happy with this solution. I've got a picture of it.
Senator, that I have my pictures as well, and seeing that and speaking as Senator Kavanaugh and I did with the constituent that lives there, is both our constituents. She is John's District 9 and my District 3 for the city council. And your characterization is correct, Senator, that she was not happy. And I think the city, that we did as much as we could on the ordinance we passed after that on the notification process. I really don't think, in my view, and respectfully, there's some that disagree, that the communication companies communicating shouldn't be that hard of a thing. And I know you guys all did your work back in, I think, 2019, when the original bill was passed. No dispute that it was something was needed, but I think it's just the unintended consequence for notification, I don't think it's asking too much to have property owners know these things are going in.
Part of though, you're on the city's right of way, and even if a property owner was notified, is there anything they could have done to stop this?
The city?
No, the property owner.
I don't believe so, Senator. Again, I'm not a lawyer, so I would have to defer that to the city
There are a
attorney.
lot of things that cities and villages do in the right of way that maybe homeowners are not happy with, but in the end, by notifying them, you're not giving them really an opportunity to object or do anything else. It's still going to happen.
It isn't, but I believe that if somebody has a contact number, you're not giving it to 100, it's just adjacent property owners to where these are going in. And if they're removing a pole and putting one in the same spot, they don't have to be notified. It's just like here where they're putting a new one in, that you have a phone number to somebody to call, and at least you have dialogue. I think that's just good government. I don't think it's overreach. I just think it's property owners, even if to your, well, you're right to say it's not going to stop the pole going in, but at least you have somebody from Verizon. They were good folks that I talked to, smart, articulate, they can explain it. Even if the property owner can't stop it, it's a good thing to have at least somebody to explain what's going on so they understand.
Okay. Senator Moser.
I think Senator Bosselman had a good point. The notification is something that the city of Omaha could do. Anytime there's something going to go in a right of way in front of somebody's house, the city of Omaha could require that the homeowner be notified rather than have a state law that says they have to be notified. And second thing, I think there is some black magic in the placement of some of those poles. I've been involved in some placement disputes when I was mayor of Columbus, and I found out later after the poles were in that some of the arguments that were used to place those poles where they went were questionable about whether it was engineering or whether it was monetary. You know, if it was these towers probably have to be closer together because this technology is a higher frequency and it's multi-channel and multi-antenna. It's got like 8 antennas and it broadcasts information on 8 channels at once. And so it is more complicated.
Sure.
But I wouldn't take the assurance of every industry person as being gospel. I would check that with somebody else, and because this is really silly.
Thank you, Senator Moser. Any other questions? Seeing none, thank you for testifying.
Thank you, Senator. Thank you.
Hello again, I'm Julie Harris, JULIEHARRIS, here on behalf of Bike Walk Nebraska. We are here to strongly support LB 731 after having seen the result of what can happen with these loopholes in the statute that was passed before. The fact that a company could construct a utility pole in the middle of a sidewalk, as we have all said here today, is just maddening. I think our point is that good Wi-Fi, whether what the signal is coming off of that pole, good Wi-Fi should never come at the expense of safe walking. And I think that's what we're dealing with here. There's some requirement for the amount of speed of the Wi-Fi, and therefore the pole needs to be put wherever it is. Our concerns about the poles are obvious. And Senator Albrecht, I appreciate what you said about kids on bikes and so on, because it's absolutely true. But we have some other issues as well. In Omaha, at least, the homeowner is responsible for maintaining their own sidewalk. So if the utility company comes in and if they don't have enough common sense or whatever to stop them from putting a pole in the middle of the sidewalk, how well are they going to construct that workaround? And is it going to crumble? And is then the homeowner going to be responsible for paying to make that better? In the meantime, now we have a unfortunate route to walk or ride or use a wheelchair. Now we've got a crumbling one, and now who's going to pay for it? Secondly, we're concerned about the smaller communities across Nebraska. At 55th and Poppleton, Jane was very fortunate to live in the same neighborhood a couple of blocks from Senator Kavanaugh. Very fortunate to have a responsible city council person to talk to. Also lucky enough to have a state bike and pedestrian advocacy organization in town who's paying attention and getting on the phone and trying to figure out what's going on. But, you know, there's a lot of communities across Nebraska, small communities that don't have that, those advantages. They don't have full-time staff to be able to check to see if a sidewalk put in has been put in well, or if it meets the requirements or whatever. So we're concerned about all the other places in Nebraska that may be dealing with this, that a utility company could come in and just say, you know, with the black magic comment from Senator Mosier earlier, you know, we have to put it here, and nobody has the ability to have any recourse. Yes, this is it's common sense. It is maddening. But having been sort of a fly on the wall to all of the back and forth happening over the summer with trying to untangle how to stop this from happening, including a complete streets policy in Omaha that requires that our streets be built to be safe for all users, which includes sidewalks. It didn't seem to be able to stop what was happening. So we just I appreciate that you're saying that this doesn't seem to rise to the level of a state law, but obviously if it happens in Omaha, down the street from a state senator, then it's going to happen all across the state, and we got to stop that from happening.
Thank you, Ms. Harris. Seeing no questions, thank you for your testimony.
Thank you.
Good afternoon. My name is Lash, L-A-S-H, Chaffin, C-H-A-F-F-I-N. I'm a staff member at the League of Nebraska Municipalities. Today, I'd like to offer the League's support for LB 731. I'd like to thank Senator Kavanaugh for introducing the bill. And I want the committee to consider a couple kind of global things that are going on. And I think when you take those into consideration, you need to take bills like this very seriously, because there's a couple things going on all across the world, and every deliberative body sees these things. Congress sees it, the legislature sees it, city council see it, planning commission see it, legislative committees see it. Every level sees everybody coming to them to saying, we need to do it faster. We need to do it bigger, better, faster, bigger, better, faster. And as they say that, the implication is the only way we can do it bigger, better, faster is, one, not have to ask permission. Two, not have to ask a bunch of questions. And third, not have to deal with the situation locally. We want to deal with it just a broad sense. We don't want to have to go to that hole and look at it. And those are the three ways everybody offers to the legislature, to Congress, to the city council, how they can get something done faster. And as a result of that, there are consequences. And consequences come from bigger, better, faster. And I think what's happening in Omaha is a consequence. And I hope you would take that seriously. As a result of the bigger, better, faster mentality, new terms have entered legislative process at the local level, the federal level. Terms like shot clock, terms like deemed approved, terms like batch applications. These are all things that go away from deliberatively looking at an individual situation. And so things like this begin to happen when a city is under the gun with shot clocks and the threat of this is automatically approved if we don't get to it in the time prescribed in the small cell law. And sure, the city has some authority, but that authority is preempted to the extent that the small cell law preempts it. And they can deny permits, but only for a laundry list of reasons. And this, I don't know if this was a reason or not. I'm not familiar with the application. I'm not quite sure where 55th and Poppleton is, but it seems like these type of ramifications come from this mentality that we just have to get it done fast. And then I think the second global thing that's going on is when I started working for city governments, and several of you have done a pass at working with city government, every utility had a local office. Gas company had a local office. It may not have been in that town, but it was 15 miles away. The gas company, the phone company had a local office, the water, the electric utility had a local office. With globalization, there are companies, utility companies, that don't really have any construction or real estate staff in the entire state. So the concept of you can't fix stupid, completely agree with it. But what happens is if it's a local company with local office in Central City, Chris and Sid, they walk over and go knock, knock, knock. Hey, you want to walk down here with us and look at that? Jesse or someone in McCook says the same thing. They go, come over here, let's go look at that. But tell me, if you can't even figure out what country you need to call to get a construction representative with a company, then that kind of common sense just goes away. And we're seeing it not only in telecommunications. I think city governments see it with every entity they deal with. If there's no one to talk to locally, then bad decisions start to happen. And if you have to call 7 people to get a hold of a real estate person who deals with these issues at the company, then these consequences are going to happen. So I would encourage you to move LB 731 forward and recognize that this mentality is going to creep its way into a lot of your decisions, as every other committee and every legislative body across the state. So I would certainly answer any questions.
Thank you, Mr. Chafin. So you're telling me this, that when somebody first saw this, if they would have made a phone call to City Hall and said something about, hey, we got a problem here, we couldn't fix this?
Well, I'll tell you what, it would be a lot easier to fix if someone saw it, okay, if the phone company had a local office. And they could go and say,
I don't care who's doing it. You look at that, and anybody with half a brain can see that you're not going to do that.
It's embarrassing.
So do we have to babysit every pole? I mean, there's hundreds of poles being put in right-of-ways all over the state.
You don't have to.
You've got one here.
Got one. But then again, I think there are going to be consequences to the speed that this stuff happens.
Big questions. Senator Moser.
So I would surmise that subsection 10 is the section that you like more so than the notice in subsection 9, because that gives the city more leverage in where the pole goes.
Senator, yes.
And so if this was in force at the time that this pole was being considered, you think this would have given the city of Omaha more leverage against the cell phone company as to where it went?
It's a good question. I'm not sure. I've thought about that a lot. I wish it had never happened. Clearly, someone was feeling the pressure to get this done fast. And
I think this technology is so complicated in how it works. And so I doubt if people in city government fully understand exactly how it works. And so I wonder sometimes whether the people who are wanting to put these poles in are being, I choose my right word here, truthful about where it has to go. Because I've seen examples where I don't believe that in cases that I had seen that the tower, either was a consultant putting the tower in and leasing it or selling it to a cell phone company, or it was a cell phone company themselves. But after it was done, I was led to believe that some of those things that they said were not necessarily requirements. They kind of bent the rules to get what they wanted to get, and that's how we wound up where we were.
You have a question?
Yeah, kind of.
Well, I will say, and I don't want to get into the truthfulness, but I do think it's fair that a city regulator be allowed time to ask questions about that, and do their own research.
Okay, thank you.
Senator Moser. Senator Bosman.
Thank you, Chairman Friesen. So does municipalities, cities have to apply by 88?
Yes.
So then why isn't it that you can't put something in the checklist and the process when they apply for this, that they have to be 88 compliant?
I suspect it was in there. I mean, I haven't seen the application, but.
Thank you.
Thank you, Senator Bosman. Seeing no other questions, thank you for your testimony. Any others wish to testify in favor of LB 731? Seeing none, anyone wish to testify in opposition to LB 731? Seeing none, anyone wish to testify in a neutral capacity? Seeing none, we have one letter in opposition to LB 731. Senator Kavanaugh, you wish to close?
Thank you, Chairman Friedman, and thank you, Transportation Telecommunications Committee, for your interest and attention to this issue. And I would thank the testifiers for coming today. And Senator Bosselman, I can answer your question about this particular issue. This was approved for a different location. So Councilman Bagley passed around, it was approved for between that spot and the between the sidewalk and the street. And then they discovered the underground wire. So then they had to move it to the inside, and they discovered another underground wire. So they moved it to the sidewalk. And that was done over email and not with the actual permit. And that is kind of, so I understand, I mean, I know you all worked so hard on 184 and all of these interests and all those things. And you're right, pulling the thread, and should we have to police every single one of these towers? And certainly no. And that would be a terrible situation. The legislature shouldn't be involved in that. The city shouldn't be involved in that. But what this statute, or this bill does, is proposes a structure under which individuals will have a little bit more ability to police the tower in their yard, and they can go to the city. In this situation, I think what may have happened if she had gotten notice that they were going to put it where they put it, is that she would have called her councilman, would have called the city, would have called somebody and said, does it really need to go there? And to Senator Mosher's point, that there is, the city does not review the radio frequency information. What happens is this company applies, I think this application had like 13 other towers on it all at once. It was a bunch of towers with specs and things. And the city just goes and says, okay, it basically almost rubber stamps them without that kind of review. And I think if we put in the notice requirement and somebody says, well, does it really need to go there? They may dig a little bit deeper on the radio frequency and see if it really needs to go there or go somewhere else. As to the ADA requirement, they are required to be ADA compliant. And what I'm saying in this situation, this specific problem was caused by the fact that they didn't consider ADA before they put in the tower, because the original approval didn't implicate ADA. It was off of the sidewalk. So they are required to comply with ADA, and that's why they had that problem after the fact. This is a situation where they're able to move the sidewalk around into her yard. As you can see, there's a good amount of space, but there are other places, and one of the reasons Senator Hunt signed on this bill is there's a few in her district that were not in the middle of the sidewalk, but abutting the sidewalk in such a way that narrows the path. And that also implicates ADA if you narrow the sidewalk to a certain amount that wheelchairs can't pass and things like that. And so I think that is one of the reasons the ADA component of this is important, is just to say it doesn't actually change their standard of anything that anybody's required to do, other than to say up front how they're going to comply. So that if the plan does not comply, then they would have to find a different approach. And the notice requirement, I think, puts more onus actually on the city to do the things that you empowered them to do under the bill. I think it was 184, the previous bill. I think that it actually, the problem we have here is no one is responsible. You said that it can't fix stupid, but the problem is when you can't find out who's the stupid person, it makes it a lot harder to fix it. And this is one of those deals where the ball is just kicked all over the place back and forth, and no one is ultimately responsible. So the notice requirement, I think, actually puts a little bit more onus on the city to inform their constituents and then do the things that they are empowered to do to avoid this situation. So I attempted to make this as narrow as possible, not to undo all the work that you've done previously, but just to make it a little bit clearer how someone can raise their objection and make sure that we are respecting the federal law under the Americans with Disabilities Act, and make sure that all of these projects do comply and that people would be able to object under that once it's put in writing how it's going to comply. So thank you for your time. If there are any questions left, I'm here.
Thank you, Senator Kavanaugh. Seeing no questions, thank you for your testimony.
Thank you, committee.
With that, we'll close LB 731. Senator Geist will take over as chair.
Do you want me to say, are your letters and stuff, do I need to read your letters? Okay. Okay. All right, we will go ahead then and open with your bill, Senator Friesen, LB 747.
Thank you, Vice Chair Geist and members of the Transportation Telecommunications Committee. I'm Kurt Friesen, CURT-FRIESEN, represent District 34. I appear today to introduce LB 747. LB 747 removes the requirement the Director of the Division of Aeronautics at the Nebraska Department of Transportation receive legislative confirmation. It makes sense that the director of an agency have the ability to appoint the right person or persons to lead department divisions in order to appropriately carry out the mission of the department. Thank you for your consideration of this, and I'd be happy to answer any questions.
Are there any questions from the committee? Are there any committee members among the committee? No. Senator DeBoer.
I'm trying to remember, Senator Friesen, the Department of Aeronautics came under is it its own? Somehow I know it used to be under the Nebraska Department of Transportation, or now it's no longer under. Which is it?
It was a separate department at one point, and we merged the two departments.
So now it's under the Nebraska Department of Transportation.
Yes.
Okay. And so is it, I don't know if you know this, is it customary that sub-chairs of agencies are appointed?
The original bill did not include the approval of the legislature, but there was a certain member of the legislature who wanted it that way, and a compromise was made to get the bill done, and so we made it so that the legislature would approve. There was serious concern back in the day of keeping a firewall between the Department of Aeronautics and the Department of Transportation. There was a lot of concern that we're going to move funds back and forth and do things like that. But I think appropriate firewalls have put into place that is not going to happen. Those two departments are very different, and funds do not transfer back and forth. So that was a concern back then, and I think they've shown that they're working well together, and there really isn't a need for the legislature to approve that person. I mean, we do approve the DOT director, and I feel at least that that's enough.
So if this is a sub-department, then what would it matter whether funds were going back and forth anyway?
Oh, you don't want to take, if there's funds that have been raised through the fuel tax on the airplanes,
sure.
You don't want those suddenly being used for roads or vice versa. I mean, they were separate departments. That was a big concern back in the day. And so we wanted to make sure that those funds didn't go anywhere else.
Okay. Well, I'm not sure that the confirmation by the legislature will have anything to do with funds anyway. So thank you.
Any additional questions? Do you plan to stay close?
I'm going to stick around. We've got more fun now.
Are there any proponents who would like to testify? Any proponents? Are there any opponents who would like to testify? Anyone in opposition? Anyone in the neutral capacity? Well, seeing none, Senator Friesen, you are welcome to close on your 747, and he waives closing. And let's see, we have no letters for the record, so that will close the hearing of LB 747. I have to say, I love that it's 747 and it's about aeronautics. It's just perfect. That's good. Now, LB 874, you may open on that, Senator Friesen.
Okay, thank you, Vice Chair Geist and members of the Transportation Committee. My name is Kurt Friesen, CURT-FRIESEN. I represent District 34, and I'm here today to introduce LB 874. The intent of LB 874 is twofold. First, to create a mechanism for approval of any fees created or imposed by an airport authority created by a city of the metropolitan class on any form of ground transportation, and to set aside any such fees imposed since July 1, 2021. The bill prohibits the imposition of a fee on gross receipts. The bill defines ground transportation as any person who transports passengers to or from an airport, A, for hire or for compensation by a taxi, limousine, bus, or van, or personal vehicle that is operated under the authority of a transportation network company, or by a hotel shuttle, parking shuttle, or other shuttles transporting hotel guests, parking customers, or other customers or passengers on a courtesy basis. LB 874 was introduced by me following action by the Omaha Airport Authority last summer, following our adjournment sine die. Last summer, the Omaha Airport Authority adopted a resolution imposing a 10% fee on the gross revenues of all off-site parking companies which transport those who use their lots. This fee, or in my opinion, a tax, is imposed on the gross revenues of a company. What concerned me about the situation is there did not appear to be an openness to receive the concerns of companies who were opposed to the fee. The process from start to finish imposed this 10% tax in 3 months. It seems to me that it was done quickly and with no oversight by any board or other entity accountable to the voters. Second, I'm concerned there's no recourse for those who may be negatively impacted by a fee of this kind. While one such company whom you'll hear from today, Park and Go, has filed a lawsuit, there were 2 others that were negatively impacted by this action. Of those 2, one has decided to pay the tax and the other has decided to close after 40 years of business. All of us have flown in and out of Omaha Airport, and we all know that there's been a lot of construction at or around that facility over the last few years. What is particularly concerning for me is that the largest recent construction project was a parking garage. This means that the airport expanded its role into the parking business. Following completion of that project, it has chosen to raise the cost to its competitors, who will then in turn pass this cost on to travelers who utilize their lot. As you can imagine, this concerns me. And following the testimony today will be Dan Williamson, a representative of Park and Go, and an individual who appeared before the Omaha Airport Authority in opposition to this tax. Mr. Williamson is very familiar with how this business works, not just in Omaha, but also around the country. So I hope you will ask him some questions. And again, it goes back to the fact that you have here an entity that was not elected, and there's no recourse, there's no appeal process other than to go to court. And they seem to have the ability to just levy a tax on property that is not located on airport grounds, but they do serve the airport. And for a 10% gross revenue fee, I just thought it was excessive without some sort of means for them to negotiate a settlement. I think as you ask questions, you'll understand more of probably where we're going with this. So if you have any other questions, I'd be glad to answer them.
Are there any questions on the committee? Oh, I have a couple. Sorry. Just a couple. I'll ask the really hard ones to the people behind you. But I think it's important for the committee to know if the airport authority in Douglas County or Omaha, is that elected by the people?
No, I believe the Epley Airfield is controlled by the city, which appoints a board to
Okay,
operate.
because
their
in a lot
airport.
of communities, it's different than that, and their airport
Yes,
authority
I
is
think-
actually elected.
It varies across the state as to how they operate. I agree. I think Lincoln Municipal Airport is different. They have an
Okay,
elected board.
okay, yeah. All right, thank you. Any proponents? Good afternoon.
Good afternoon, Vice Chairman Geist and members of the Transportation and Telecommunications Committee. My name is Daniel Williamson, spelled Daniel, D-A-N-I-E-L, Williamson, W-I-L-L-I-A-M-S-O-N. I am Vice President and Head of Development and Public Relations for Park and Go. I appear before you today to support LB 874, and we appreciate Senator Friesen's introducing of that LB 874. Park and Go is a surface parking company that is located in close proximity to Omaha's Epley Field. Our facility is at 1515 East 4th Street on private property, about 1 mile from the airport. Our customers park at our facility. We then assist them with bags and other kinds of services and transport them to and from the airport. We've been in business since 2000, and we've always enjoyed a good working relationship with the Omaha folks and continue to try to operate that way across the country. However, last summer, we faced a sharp difference of opinion on an action taken by the Airport Authority Board. Last summer, as Senator Friesen stated, the board instituted a 10% tax on our gross revenues of business. You heard me right, 10%. We're a volume-based business, and if you know how volume-based businesses work, the margin is slim. So 10% is more than a normal amount to have to introduce into your business platform on a sudden basis. Their basis, as we understand it, is to recover costs associated with our access to the Omaha airport grounds. Okay, what does that mean? That mean wear and tear in the asphalt, gate transaction machines that lift a gate and let us in and out. I, on behalf of Park and Go, objected to the fee at the time of the hearing before the board. That was back in July. But it became quickly obvious to me in the board's response to me that they were not interested in my objections and they were going to move forward and vote that day, which I was a little surprised. I've worked with many airports across the country, and usually there's a dialogue and a process to try to negotiate a win-win agreement. We objected to the fee at that time based on the following 5 points. First, the use of a percentage gross tax is not standard throughout the industry, even though it's portrayed that way. Park and Go has operations all across the country. Some of them have zero fees, much like Omaha did. Some of them have a trip fee, and some of them have a percent of gross fee, which ranges, all different percentages. The consistent idea is to contribute to the general maintenance and the welfare of the airport. We all want a healthy airport. We all want a vibrant airport. We all succeed better when they are such. Second, the Omaha airport is a competitor. Can you imagine Burger King calling McDonald's and saying, I want to see your books and I want 10% of your gross revenues. And then, by the way, I'm going to use those revenues to market against you and compete with you. There's no reasonable way to receive that well. As Senator Friesen noted, the Omaha Airport Authority just completed a major construction of a parking operation, a big expansion, and they did that during the COVID event. Third, speaking of the COVID event, the travel industry has just begun to recover from one of the worst economic events that we have seen historically. And most of the airports are predicting about a 2023 recovery, so we're still not there yet. Now the Omaha Airport wants to tax us 10% on our gross revenues. One of our other competitors, which was Stewart Parking, made it clear at the meeting that this would put them out of business, and they have since relinquished their business. A free market is important to the American system. And a free market means that a monopoly is not beneficial to a free market. We believe the public gets better service and a better value when there are multiple competitors. We have many cities where there's 4, 5, 6 different parking operations competing with the airport. And what I like about that is it makes us all service you better, provide a better rate, and frankly, it helps the airport do the same thing. We know airports that have raised their tax on the parking facilities to 20, 30%. And frankly, the service at that airport is very, very, very poor. We've also sat at meetings or at restaurants and been eating, and a guy behind us suddenly says, gee, we're going to just keep raising those rates till we put that parking operation out of business. And we, of course, turn around and say, by the way, we're with Park and Go. We just overheard that conversation. And would you like to say that again? So we know sometimes there's method that's not as polite as we'd like it to be. Fifth, all we're really looking for is dialogue. We would have liked a dialogue like we've done with many, many other airports where we've negotiated a fee structure that would have worked for us and the airport.
So your light is red.
Oh, does that mean I have to stop? Okay, I'm sorry.
It does if you'd wrap up quickly.
I will wrap up quickly. Park and Go wants to, first of all, just thank you here at the committee for hearing our testimony. And I'm here to answer questions.
Thank you. Thank you for your testimony. Are there any questions? Yes, Senator Hughes.
You
Yes,
said you had
thank
hard
you.
ones.
For coming in today. So was there, I guess I'm looking for the numbers of parking slots at Epley. Was there a critical shortage? I know they just built the new parking garage across from the terminal. Was that indicated before COVID, or can you share any numbers with me that would indicate the capacity versus the need of parking?
The demand on parking appears to be growing across the whole country. It just appears to across. I mean, Minnesota just added their silver ramp, which was, I think, 7,000 spaces. I'm going to let the Omaha folks, since I know they're in back there watching the back of my head, I'll let them answer that question directly. I know that we expanded our facility. We doubled our size with the anticipation of the demand on parking. So we had increased our parking at Omaha.
When did you do that?
We did it prior to the COVID experience,
So,
let's say 4 years ago.
okay, so 2017.
Yep, roughly.
Okay. So the company that went out of business, how big of a parking lot was that? And was
They were-
that on private property?
Private operator, Senator Hughes, and smaller than ours. I want to say they were under 1,000 cars.
Okay. So currently you don't pay any access fee to the terminal,
Up to the date that they passed that resolution, we did not.
but you do now.
I believe we are now, yes.
In addition to the 10% of the
No,
gross?
10% only.
Oh, so that is your access fee.
That is our access.
So you're not paying a fee every time you
Nope.
go to the terminal?
No, we don't have that right now.
Okay. So if you, as you stated, your company is based off volume,
Yes.
so the margins are thin. So in order for you to recoup this, you've got to raise your prices, and that in turn raises the tax for the airport authority.
That's right. We would have to pass that price on to the customer.
That is a double tax, if you will, or a win-win for the applicant. Okay, very good. Thank you for coming.
Thank you, Senator Hughes. Any additional? Yes, Senator Mosher.
Do some airports just charge so much for every trip you take through the airport?
That is correct. That's what we have in Minnesota as an example. We have a trip fee.
So somebody who goes on vacation for 2 or 3 weeks, they're gonna have $100 parking bill?
Depending on which airport, in Minnesota, if you.
Well, I
stay-
mean, it's just saying your lot where you know what the deal is. I mean, it's $10 a day at least, probably.
At least, yes.
Yeah. And so you're gonna pay 14, if it's 14 days, $10 a day, you're gonna pay 10% of that, you're gonna have $14 you pay the airport. Whereas if you got $5 every time you drove through, you'd be charged for what you're actually wear and tear on the streets and all those sorts of things rather than on your gross.
Senator Moser, that is correct. It's.
But other airports do charge a gross tax?
Some do, yes. That is
Are
correct.
they as high as 10%?
Some are as high as 10%.
So this bill is just, it's not going to guarantee that you get a better deal. It's just going to give you a little leverage.
The idea with this bill would be that the airport would have to come to us and work on a negotiated fee.
But still, if they want 10%, and you don't want to pay it, then you're kind of back right where you are.
Then we have to fulfill our court case, yes.
Okay, thank you.
Yes, Senator Albright.
Thank you, Vice Chair Geist, and thank you for being here. I just want to point blank ask if you are in court over this with that operation.
Yes, we are. I didn't read that part because I was cut a little short, but I'll just read it quickly to make sure I got it correctly. We currently have in Douglas County District Court, and we've gotten relief on this case, which means it's going to go to a court case. Okay, the dismissal didn't occur. In other words, it's got to move forward. That is correct.
Okay, and some of these other airports that Park and Go are at, do they have the ability to do what Omaha has asked of you to charge an extra amount?
Airports that have tried to do this after the fact, we've had to either negotiate or we've had to go to court. And I think the difference that needs to be clarified is when we go to develop a piece of property, just like any business, you look at the cost of the land value, the availability of the land, the costs of operating your business in that particular community, the possible revenue stream. So when we go into a city and they say, here is our fee structure at the airport, we know that. We build it into the program and we go, okay, this can be a successful business. When it comes after the fact, there's no way to mitigate that. It just has to be handed off either to the customer.
Okay, so real quick, how long have you been there and been a service to the Omaha Airport? How many
We've been
years?
there since 2000.
2000, and how many stalls?
We have about 880 on the one lot and another 700 on the second lot.
Okay. Thank you.
Any additional questions from the committee? Yes, Senator Hughes.
Yes, thank you, Senator Geist. So is there any kind of a distance from an airport that you could build a parking lot that they wouldn't come after you? Or say that regardless of what you're providing parking for, whether you're providing parking for and transportation to Rosenblatt, or not Rosenblatt, what is it now, the ball field, or to UNO, or to the airport, or to the casinos in Iowa? You know, does the airport have any distance requirement from their facility that they can't?
None that I know of, and because they're auditing our books and taking gross receipts, even if those customers used other services to go to other locations, they still would be accessing that 10% tax from us.
Okay, thank you.
Any additional questions? I have just,
Do you have an agreement to use the access to the airport now without a tax? And you're saying that they instituted this tax after you had an agreement to operate?
We've been operating for 20 years with an
But
agreement.
do you have a contract with them?
You know, I'd have to look and see how that read. We do have an agreement that allows us to go in and out of the airport. Yes, every airport has
And
that.
what's the term of the agreement?
Well, it changed. With that resolution, it became a new agreement.
Well, you can't unilaterally change a contract unless something changes, right?
Well, the ordinance changed that.
Okay, thank you.
okay, I have one question. It's probably not hard at all because everybody's used up all my questions.
Okay.
Was the Stewart Group the only other private entity that was operating at the airport, or is there currently more than just you?
There was one other, and they chose to pay the tax, is what my understanding is.
Okay, so the same imposition of 10% was made upon them as well
That is
at the
correct.
same time?
Yes.
Okay, thank you. Any additional questions? I think that's it. Thank you very much for your testimony. Any additional proponents who would like to testify? Seeing none. Any opponents who would like to testify? Good afternoon.
Good afternoon, Vice Chairman Geist and the rest of the Transportation and Telecommunications Committee. My name is David Roth, Davidroth. I'm the Chief Executive Officer for the Omaha Airport Authority. The Omaha Airport Authority is a non-taxing political subdivision founded in 1959 and charged with exclusive jurisdiction, care, custody, and control to develop, operate, manage, and oversee the airports in Omaha, Nebraska, including Epley Airfield. Board members of the authority are appointed by the Mayor of Omaha and approved by the City Council. To cover airports costs, airports such as Epley Airfield collect fees from businesses that directly benefit from the airport's operations and use its infrastructure on a daily basis. Some such businesses, like the airlines, help generate the customer base. Others facilitate aviation activity. Still other businesses, such as off-airport parking companies that derive virtually all of their revenues from airport-related operations, tap into the market of customers created by the airport's existence. The Omaha Airport Authority is the only airport authority in Nebraska that does not have the power to tax, nor does it want the power to tax. Instead, the City's Airport Authorities Act specifically authorizes the authority to quote, let me take this off, charge fees, rentals, and other charges for those use of projects. And projects is defined as the entire airport under the jurisdiction of the authority. Since it receives substantial federal funding for airport development, federal grant assurances require the authority to, quote, maintain a schedule of charges for use of facilities and services at the airport in order to make the airport as self-sustaining as possible. As part of a multi-year ground transportation strategy, the authority began collecting user fees from ground transportation providers at Eppley Airfield. This group includes Uber, Lyft, taxis, limos, rideshare companies, and off-airport parking companies. The user fee is a charge for the use of the airport and its infrastructure, including access to the roadways and commercial vehicle lanes at Eppley Airfield. Last year, the authority passed the off-airport parking company user fee resolution to charge user fees to vendors characterized as off-airport parking companies. The resolution charges a fee of 10% of gross receipts received by vendors from their shuttle business services at Eppley Airfield. Similar fees have been fully litigated and upheld in the courts. They are charged at airports across the country, as can be seen in the chart that I have attached to my testimony, indicating fees imposed by our peer airports. These charges are also recognized by the FAA. However, at this time, we are in litigation. LB 874 seeks to outlaw authority charges to off-airport parking companies that are based on a percentage of gross receipts. It does not prohibit other charges such as trip fees, although any fee collected by the authority would require approval of the state director engineer of the Nebraska Department of Transportation. Design of a new terminal at Eppley Airfield is underway, with construction expected to start in 2023. The project will be funded by the cash reserves accumulated from the Airport Authority operations, revenue including user fees such as the subject ground transportation fee, along with FAA grants, passenger facility charges, TSA grants, and new revenue bonds issued. The authority has always managed its finances prudently with fiscal responsibility. To involve state agencies in this process or to prohibit a particular type of fee would interfere with the authority's fiduciary responsibilities to our bondholders and to the FAA. To prohibit fees of gross receipts charges to prohibit fees on gross receipts charges is unnecessary, highly unusual, and without precedent. This legislation will negatively impact the financial profile of the authority. If enacted, LB 874 will create a negative impression on the authority in the capital markets. Any political involvement in its operations of an airport is a significant negative feature from the point of view of the rating agencies, investors, and the airlines. It is highly unusual to require an airport to seek state approval for the imposition of the fee needed to effectively finance airport operations. And in closing, fees levied on ground transportation companies are common at airports nationally and are strictly determined by airport management. Any negative credit impression from the investors will increase our interest rates at the authority when we borrow money, which will increase our operating costs and burden users of the airport facilities. The market expects airports to maintain a strong financial profile, and having the ability to set rates and charges and collect user fees without political interference is a crucial concern. Eppley Airfield is a successful airport for Nebraska because it operates the way it does. Changes like LB 874 put that at risk. For these reasons, the Omaha Airport Authority opposes LB 874 and respectfully requests it not advance. Can I please answer any questions?
Sure. Thank you for your testimony, Mr. Roth. Are there any questions? Senator Hughes?
Yes. I have flown in and out of Eppley several times. I live a lot closer to Denver International Airport, a much larger airport. So parking facilities are 5 to 10 miles away, but they also serve other facilities other than just the airport. I guess the part that is really bothering me is the 10%. If you have a person that is gone for a day and he parks at Park and Go or whatever the other gentleman's facility was, he pays $10 a day, you get $1. He made 2 trips to the airport. They hauled him in, he got on his airplane, they came and picked him up when he came off. You've got a guy that's gone for 10 days and he paid $100, you get $10, but they still made 2 trips in and out of the airport on public roads. So to me, the 10% is very arbitrary and very unfair. I think a gate fee for the the amount of times that they circle in and out of the airport would be more appropriate. Just some thoughts.
Thank you, Senator. If you look at the chart that was attached, we did substantial reporting on this and some benchmarking on this. And you see a lot of the other airports that are situated similar to Epley, 10% is very, very common. As a matter of fact, when you go back to the Airports Cooperative Research Program, they did a study on ground transportation, and one of the predominant ways to collect fees from an accurate standpoint is gross receipts. And they also recommend that. It is a way that we can actually get the percentage of actually the amount of parking revenue coming into those parking companies. If you do based on trip fees, there could be one person on a bus, there could be 15 people on a bus. One thing that the FAA wants to make sure that we do is that we're equitable across the board on the utilization of the facilities and how we collect those fees.
I have a follow-up, Madam
Sure,
Chair.
go ahead.
So how do you charge taxis and Uber and Lyft? What's their fee schedule?
First of all, we don't collect taxes. They're
How do you
strictly user
generate
fees.
revenue from this?
Yeah, we raise revenue with them with trip fees. So every time Uber or Lyft come across the drive, they have equipment actually in their vehicles provided by the company, and then they report those to us from the Uber and Lyft companies. So they actually have equipment, GPS equipment that they have installed in their equipment.
Okay, thank you.
Yes, Senator Boston, go ahead.
Okay, thank you, Vice Chair. Vice Chair, guys, thank you. Thanks for coming and testifying today. I guess I got some questions for you. How much then does those Uber taxis pay per time? You're asking 10% gross from these off parking areas. What's the percentage for an Uber driver?
The Uber driver
is it 20%?
I believe it is, it's either $1.50 or $2 trip fee. I'd have to get back.
You know what that would be to their gross income?
It's not gross, it is a.
I understand that, but you're charging off of gross for the park and go.
Correct.
So why wouldn't you charge on gross for these guys?
When you look at the industry standards on the off-airport parkers, it is more consistent to do gross receipts fees.
Okay, appreciate that. I'm looking at the airports you have here that you're comparing to, and they're significantly larger than Omaha. Omaha, I think, would be more in the Oakland, Jacksonville. Omaha is not nearly the size of, I would say, your Cincinnati's, your Dulles and Portland's. I think your number, I think that putting Omaha in that category is, I guess one justification as to how many flights come in, how many passengers. I think you're probably lower significantly in some of these. My other comment would be, you're just gonna charge me more money. So rather than charging me more money, why don't you lower the rates in your parking garage so I can afford to park there?
The parking garage, when we built the new parking garage in about 2017, I believe is when it started, we were closing that parking garage about 3 to 4 times a week. So we needed the capacity to increase. We chose the investment that we did. We actually have rental car facilities in the first 2 floors, sharing that cost as well. And then the top 4 floors are in the parking garage. Interesting enough, last month or in December, we actually filled up both of those garages. So we are seeing, as the gentleman who spoke before me, we are seeing increased parkers. Actually, their behavior since COVID have changed significantly. We are getting more parkers coming into the parking garage.
So why is it when you built those, wasn't in the design or I'll call it the feasibility study, business plan for that new parking garage that pays for itself? I mean, to me, instead of going out to charge someone who you've never charged before in the history, and now all of a sudden you're going to go at a significant rate. So why, I guess that's, I'd like to understand that.
Yes, the transportation, the ground transportation fee has nothing to do with paying for a parking garage. That's based on our revenues coming in from the parking garage. Actually, the rental cars pay 2/5 or 2/6 of that parking garage. So revenue coming in from Park and Go is not going toward that. It's going into the general fees. And as the FAA has required us to charge fees to all users of the airport facilities, we just started to charge fees on ground transportation. And we started looking at that about 5 years ago because the market changed. Uber and Lyft did not exist before that. We had off-airport parkers. We did not have Ubers and Lyft. Now that Uber and Lyft comes into play and the increased off-airport parking, we utilize more law enforcement officers. We probably doubled those numbers, so operational costs increase. We also have the maintenance operations of our facilities. And if you've been by the airport in the last 8 to 12 months, we just started construction of a new entrance roadway, which is part of our overall master plan for the facility.
So, and one last one. So as Senator Hughes had said, and you have it in here in 5, the user fee is a charge for use of the airport and its infrastructure. That's a public road. That's public infrastructure that got put in there.
The roadway is not, it is part of the Omaha Airport Authority property. It's not part of the city.
Part of the, say it again?
The Omaha Airport Authority.
And is there Omaha Airport Authority private?
Is it private?
Is it a private business or is it
It's a political subdivision, and we
Okay.
have care,
So it
custody, and
is,
control.
so it is a government roadway then?
Funded by the fees that come into the airport authority, authorized by the city's
Okay.
Airport Authority Act.
Thank you.
Thank you, Senator Bosselman. Senator Mosher. Yes.
Did you call me Grony?
No, I called you Mosher.
My hearing must be going
No,
bad. I take
see
that
you
as a
clearly.
compliment anyway. Do they charge sales tax on parking?
We do not charge any sales.
But are the parking garages required to charge sales tax?
The parking garages belong to the Omaha Airport Authority, so no.
Well, I mean, the ones you're charging the 10% to, the off premises.
That I don't know. We don't get into their business.
This chart says select airports. Are there some airports that don't charge fees?
The good percentage of airports in the United States charge fees to come on airport property as a user fee, correct?
But you stopped at Oakland, but there are some to the left of that charge less or no fee?
The ones that don't charge fees, I don't know the number of that. I can't get that to you. But the majority and the best practice within the industry is, yes, charging fees.
Thank you.
Yes, Senator Kavanaugh.
I just want a point of clarification. So on number 3 on your testimony, you said that the Omaha Airport Authority is the only airport authority in the state that cannot levy taxes.
Correct.
Okay. And I'm assuming, but please correct me if I'm wrong, that is because it is not an elected airport authority. It's basically a subdivision of Omaha.
It's in the metropolitan class.
Okay.
So it's above a certain number of passengers. So it's in a metropolitan class.
So the Lincoln Airport Authority could charge or levy taxes that the Omaha cannot.
I believe, yes.
Okay, thank you.
Any additional questions from the committee? Yes, Senator Albert.
Thank you. I just have a couple quick questions. So if you're going to start charging this company that's been good to the Omaha Airport for 20 years a tax, will you then start charging anyone who drops us off to go to the airport a fee?
On the front drive, if you're getting dropped off, no, we don't do that. We're just dropping companies who are making money off airport or on airport, then we are charging a user fee for
But
access.
would you say that over those 20 years, you were grateful that they were there?
Oh,
because you
absolutely.
didn't have enough parking?
Absolutely. Yeah, during peak times, it's great to have parking go there because they'll take on passengers. They've got a good solid base of customers. And matter of fact, as I've driven by their parking lots, as numbers have come back from COVID, the lots are filling up, our lots are filling up. And to me, that's a good thing.
So I just want to make this comment because when I go to the airport, I don't like walking through big monstrous parking garages. I love the fact that I can just go there. They pick my luggage up out of my car, put it in there. I like the price. Usually it's on somebody else if I'm going somewhere, but It's really a nice service. It's unfortunate that there can't be something worked out. I'm just saying that to have a nice long vehicle to go back to your car in, and as a woman, not, and maybe a man too, who knows, but it's nice to have the convenience of the park and go. I would just say that, so.
Thank you.
Any additional, yes, Senator Hughes?
Yeah, I'm not familiar with the footprint of Epley, but it looks to me like you're pretty landlocked, or do you have room for expansion? You said that you were anticipating building a new terminal. Is it going to be larger? Or
Yes.
Do you have room to expand?
Yes, where we're expanding is right on top of ourselves. So we will be renovating the existing terminal, and we will be expanding, making it much more efficient for the airlines, TSA, so that the process is very seamless as you go through. We're going to be building very much in the same footprint, except we will, instead of 2 concourses like we do today, 2 separate checkpoints, we will have 1 concourse. And the other caveat of this is all the concessions. The way after 9/11, most folks wanted to get through the security checkpoint so they could get concessions relaxed before they got on an aircraft. We don't have a whole lot of concession opportunity in the current layout. The concessions, majority of them will be after the security checkpoint.
So are you going to build out kind of a lane or something for planes on both sides?
Correct. It'll be the landlocked issue. We will be on one side on part of the new concourse, and it'll wrap around on both ends of it.
Okay, so what kind of a price tag is that? Are we
Right.
looking at?
Yeah, right now, we're in the design phase of that, and the original preliminary estimates are around $600 million.
Wow. So how much did the parking garage expansion cost, just ballpark?
Yeah, the parking garage was, I think the bids on that were 69 million.
Okay, and you came in about on budget.
Yeah, we came in under what we had budgeted for.
So kind of what's the ballpark of what's your operating budget to maintain runways and terminal and parking and?
Can you excuse me?
Your main, what's your operating budget?
Operating budget runs 2020, it was, I believe, $25 million in operating budget.
Okay. And how many airlines have flights into Epley?
We have 7. We run, it changes seasonally. We run between 70 and 90. Again, COVID has changed things significantly.
70, 90 flights per week?
Flights per day going out.
Between 70 and 90?
Yeah, in that range.
Okay. So I guess I understand why, and this is not a criticism of you, but to me, it just defies logic that Lincoln and Omaha don't have a regional airport halfway between Lincoln and Omaha. The opportunities to get a direct flight to anywhere is much greater. I'm planning a trip to Texas. I'm flying out of Denver because I can get a direct flight at a heck of a lot cheaper price. Yeah, I'm spending more miles on the highway, but my time is worth something, and the tickets are a heck of a lot cheaper, and not having a connector flight through Denver, through Charlotte to go to Texas, or through Miami. So rather than, taking $600 million to build a new terminal, and the city of Lincoln or Lincoln Municipal Airport is having trouble getting enough airlines, enough passengers, let's take a look at that. Let's do something for the citizens of eastern Nebraska so they're not driving to Kansas City, so they don't have to have a 1-stop or 2-stop to get where they go, or everybody in western Nebraska goes to Denver because you can get to places from there. Just a comment. Thank you.
Any additional questions of the committee? Seeing none, thank you for your testimony, Mr. Roth. Are there any additional opponents who'd like to speak? Good afternoon.
Good afternoon, Madam Vice Chair. Senators, my name is John Large, Jon space Large. As the immediate past president of the Nebraska Association of Airport Officials, I'm here to testify in opposition to LB 874. Whether they are fuel flowage fees based on the amount of fuel a private operator might distribute, or an operating fee an aerial applicator might pay to utilize an airport during the summer spraying season, or a gross revenue fee charged to an off-property business operating at an airport, fees and charges to those using airport infrastructure are a key component of the operational funding of any airport, from largest to smallest. By requiring state approval of any fees and precluding the use of certain types of fees, the association sees this bill as placing all airports in the state on the brink of a slippery slope, jeopardizing future abilities to charge businesses for the use of an airport and eroding one of the foundations of its financial support. Now, this foundation of an airport's financial structure is not optional. Charging fees to airport users is tied directly to federal grant obligations that any airport receiving federal funds has agreed to. The specified grant assurance, among the many that are required, assures the FAA that in return for the federal funds, and I'm quoting here, it will maintain a fee and rental structure for the facilities and services at the airport, which will make the airport as self-sustaining as possible under the circumstances existing at the particular airport, taking into account such factors as the volume of traffic and economy of collection. Perhaps most disturbing about the proposed bill is that while it does not preclude a fee to an airport user, it does take the control for this obligated fee and rental structure out of the hands of those making the assurance to the federal government and places it into the hands of those with no responsibility or authority or consequence for the fee and rental structure that makes the airport as self-sustaining as possible. Finally, we believe this proposal assumes a level of knowledge and depth of understanding of the process of developing and establishing fees and rental structures that may not exist. This is a highly complex undertaking requiring significant experience and background knowledge. While the department/division is highly experienced and well qualified in the processes of federal grant management and does a commendable job of helping the state's airport sponsors to navigate the waters of airport development, reviewing and approving of an airport's fees of any kind seems well outside of the department/division's purview. Rates and charges for anything, from hangar rental rates to fuel flowage fees to business operating agreements, and the form that they take, should be the sole responsibility of the state's individual airport sponsors based on their own unique situations. To think that the department/division should ever assume a regulatory role in the definition of an airport's finances is far beyond where this association believes they should ever go. For all of these reasons, the Nebraska Association of Airport Officials feels that this bill, again, puts us on the brink of a slippery slope that could impact every airport in the state, and we would again state our opposition. So with that.
Are you done? I didn't mean to.
Yes, ma'am, I
am. Okay, because you still have a little bit of time. I wasn't going to cut
Yes,
you
ma'am.
off. All right.
Don't encourage him to keep talking.
Well, thank you for your testimony, Mr. Large. Are there any questions on the committee? Yes, Senator Cavan.
Thank you. Thank you, Mr. Large, for
Yes,
being
ma'am.
here. Just in hearing your remarks about the authority to levy fees and rereading the language here. So am I to understand correctly, and I guess also looking at the fiscal note from the city or from the Omaha Airport Authority, took into account just estimating fees that they collect for rideshare, taxis, limos, et cetera. Would this bill prohibit them from collecting those fees that they currently collect without the approval of the director? Sorry, it was probably a question I should have asked to the Omaha Airport Authority.
I think I would not want to address that.
It's fine, I'm sorry, I was a little slow on processing that, so previous testifier, thank you.
Any additional questions from the committee? Seeing none, thank you for your testimony. Any other opponents to the bill? afternoon.
Good afternoon, Senator Geist and members of the committee. My name is Scott Terry, Scottarry. I am Director of the Aviation Institute at the University of Nebraska, Omaha. I'm also serving currently as the chair of the Nebraska Aeronautics Commission. I want to be clear, though, I'm not speaking on behalf of the university or the commission today. I'm speaking on behalf of myself as somebody who has been engaged in aviation for most of my career in a number of different capacities. I first want to start with Senator Hughes. I had to give you an amen on the idea. Some of my friends back here I've assigned that project that you suggested. Why don't we build an airport between Lincoln and Omaha? And one of the reasons we don't is because of the politics. It would be insane because where you put airports is really contentious, but the students really get a lot out of that exercise. I want to take about a 30,000 foot view, if you don't mind the aviation pun. I think you've heard a lot of the specifics about what this bill is, the rates and charges and fees that the airports use to support their mission and what they're trying to do. I'm speaking against Legislative Bill 874 today because I don't think it's necessary. And I think it misses the point about how our airport system has evolved in this country. If you go back way back historically, we had a real mess of a system of private operators and public operators and who was going to benefit from the airport and who was going to pay their fair share. And fortunately, we've ended up in a place with our large commercial service airports like Omaha, where the airport doesn't go into the community in tax. It charges fees to people who use and benefit from the airport. And so if you fly into and out of an airport, you pay a fee. If you are a service provider that is benefiting from that airport being there, you pay a fee. You contribute to the well-being of the airport. Our commercial service airports depend on local government structures. They depend on cooperation between airport managers and other stakeholders, and an understanding that everyone who benefits from the airport is responsible for paying for the airport. Not just that specific one-time use, but for the future of that airport. As was mentioned by some of the other people who testified, the system of grant assurances and restrictions and agreements that are in place are imposed so that the investments that are made in the airport facilities are there for the long term and they're sustained. I've studied a lot of airports, and like many of you, I've visited a lot of airports. And frankly, our airport in Omaha is something to be proud of. It's run very well operationally. It is run prudently, and it has a vision for the future that I think we should all be excited about for Nebraska. There's always a question about spending $550 million on terminal expansions and so forth, and what does that mean? I think we need to look forward. We need to look ahead with those kinds of plans and know that that's going to benefit not only the people of Omaha, but the people of the region. And it's responding to the demands of the market, which I think are important as well. The Omaha Airport is governed by a politically appointed board, a board of business people, civic-minded business people who have not just the interest of the airport in mind, but also the interest of the community. And they really demand accountability of Mr. Roth and his staff, and that's important to note. One thing that's, I think, interesting about airports that a lot of people miss is that they're public entities that really operate like businesses. Their business partners in commercial airline, the commercial airlines really demand this after deregulation. They demanded that these airports are efficient and effective and that they do what they can to run their operations prudently. And a few of the speakers talked about fiduciary responsibility. This is a real important issue for those that run commercial service airports in this country. And I think Omaha does an exceptional job of that. The point is that the system that we have effectively distributes the cost of operating the airport the community needs to those who benefit from its operation, either as customers or service providers. The airport doesn't go into the broader community and ask for tax dollars. It does not seek funding from people who don't directly benefit from the airport. In short, what I'm saying, whether by intention, some sense of luck, or combination of the two, we ended up with a system of airport ownership and governance in this country, and in this case in Omaha, that works. There are enough checks and balances in the system to ensure that airport operators are accountable to both the public and their various business partners. We don't need another layer of government or oversight or intervention in this regard. And for that reason, I believe that LB 874 is not necessary.
Thank you for your
Happy to take your
testimony, Mr.
questions.
Cherry. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Any additional opposition to LB 874? Is there any neutral testimony for LB 874? Good afternoon, Director.
Good afternoon, Vice Chair Geist and members of the Transportation Telecommunications Committee. My name is John Selmer, JOHN-SELMER, and I am the Director, State Engineer of the Nebraska Department of Transportation. I'm here today to offer testimony in neutral capacity. I thought it was worthwhile for me to be here, hearing how well I'm spoken of as another bureaucratic entity and looking at airport fees. It's been an interesting discussion. Has been discussed with many of you, and I won't take much time. The FAA requires airports to charge fees to companies that operate on airport properties or profit from the entity or an airport being in business, such as airlines, restaurants, gift shops, limousine services, ride shares like Uber and taxi services. And all those fees are required to be fair and equitable. And I believe this bill is talking about equity, being equitable and fair in terms of ground transportation. This bill, as it's written right now, would affect the airport's authority to charge fare fees because it calls for suspending fees that were imposed after July 1, 2021 for ground transportation companies. We believe this is neither fair or equitable to the other entities that are currently paying for fees out there. This can also be expected to be a fee increase on other airport businesses in order to make up for the loss in receipts from ground transportation operators. Suspension of the ground transportation company fees beginning from the passage of this bill through the regulatory process up until the airport authority can apply for and receive approval for fees will allow all those companies to operate without cost on facilities constructed with public money. Knowledgeable business professionals with an in-depth understanding of the large and complex business of owning and operating Epley Airfield, other airfields such as Lincoln Airport, Millard Airport, and other individual airports across Nebraska. They currently set the rates and the charges at these airports. The setting of those rates and charges is one of the contractual obligations the authority acquires when it accepts grants through the FAA Airport Improvement Program. As such, there are FAA compliance determinations on the amount and manner of setting those rates and charges, which are not set in a vacuum. Currently, as expressed, NDOT does lack the knowledge and the expertise to determine the appropriateness of the rates and charges set by the Omaha Airport Authority. And I think what it gets into is this is changing the role that historically either the Department of Aeronautics or the Department of Transportation has involved in this. To us, I think our concern is that even though we're neutral here, is that it's more than just looking at whether it's fair or equitable. It's really getting down into the finances, into the strategic planning, and really, I think, taking on a role that we're not necessarily comfortable with taking as the Department of Transportation. Is that rightfully our role, or is there another entity, a local government, or a different way of doing business to address the concerns that have been brought up here today? And I'll stop with that and be happy to answer any questions.
Thank you for your testimony. Senator Hughes.
Yes, thank you, Director Selmer, for coming in today. So I guess I had similar concerns that you do, and my thoughts are, would the Public Service Commission be a better oversight entity to handle this? Just giving Senator Friesen a heads up that he can answer that when he shows up. But Public Service Commission regulates a lot of taxi fees, all sorts of things. So that seems like that would be a better fit, and you would be off the hook.
I'd like to be off the hook. So maybe I'm not so impartial here, but.
Any additional questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Is there anyone else who would like to testify in the neutral capacity? Seeing none, Senator Friesen, you are welcome to close on LB 874.
Thank you, Vice Chair, guys. I'm just going to try and make it real short here. I guess the biggest concern I had is you have an unelected body arbitrarily raising a tax. And if the politicians that run the airport want to take a vote, raise a tax, let them take credit for it. But when you just let a board, 10% of gross revenue, when you have built a garage that's directly competing. So when I fly in and out of Omaha, I love flying in and out of there. If I'm going to be gone for a long time, I go in the long-term parking and it saves me a bunch of money. And I ride the park and go and I go to the airport. But if you're just trying to make it competitive, so you're driving me to the underground or the covered storage through tax policy, I mean, that isn't quite fair to private business that's offering this service. So I don't think Park and Go has ever indicated they don't want to pay a fee to have access. But I think the way it was implemented and basing it on gross revenue, when if I'm going to stay in for 2 weeks, they're coming with a bus that hauls numerous passengers. It doesn't clog up the driveway. It relieves congestion there. It helps out the airport. And yet you're giving them 10% of gross revenue of the business they do. To me, it doesn't make sense. I mean, they should be encouraging that instead of discouraging it. And so I guess from that standpoint, there's just a couple of those things that I think there's a place for everybody to sit down and negotiate a settlement here. But the way this whole process was handled with no ability to negotiate or appeal it to a higher place, whatever, this is not how we implement taxes in Nebraska. There's usually an elected body that has to take a vote, has to do something that implements that tax. And so just the process of the way it was done, I'm open to changing who makes that decision. But in the end, it looks to me like the way it was handled is not a fair and equitable for private business that wants to offer a service that, to me, makes that airport better. And when you look at airports, I will say that they get a lot of money from the federal government. So those are my tax dollars at work. And so a lot of that is what I would call public property. So with that, I'd be glad to answer any questions.
And are there questions? I'm going to go to Senator Kavanaugh real quick.
Thank you, Chairman Friesen. So you said an elected body should be, doing the fees. And the Omaha Airport Authority is not an elected body. They're appointed by the mayor. And so in Lincoln, if they wanted to do this, they are an elected body and they can levy taxes. But in Omaha, that's just not the case.
Correct.
So did you, in drafting this legislation, did you consider giving the authority to the city of Omaha?
I didn't work with drafting most of this. It was given to me and it was a bill that I just saw a need to do. So I think they're open to, from what I have understood, they're open to negotiation. It's not as though they don't want to pay any fees. They just thought that this was arbitrary amount and based on gross revenue wasn't fair.
Okay, so you'd be open to the authority going to the oversight and authority going to the elected body of the city?
If the Omaha City Council would vote to implement this, that would be a whole different process because they would hold hearings then, they would determine the need.
Sure.
None of that was done in this process.
Okay, thank you.
Senator Hughes, did you have a question?
Did you consider giving the authority of oversight to the Public Service Commission rather than the Department of Transportation?
Never occurred to me.
Okay. But you'll think about it, right?
I'd think about it, yeah.
Are there any additional questions on the committee? Seeing none, I will let you know that there were 6 online comments in opposition to LB 874. And with that, we will close the hearing on LB 874. Senator Friesen, you're back in charge. Would you pass that down to Sally, please?
Okay, with that, we'll open the hearing on LB 913. Welcome, Senator Bosselman.
Good afternoon, Chairman Freeze and members of Transportation Telecommunications Committee. My name is Bruce Bostelman. I spell that Brucebostelman, and I represent Legislative District 23. I'm here today to introduce LB 913, which will require the Department of Transportation to reconstruct a highway approach when it's destroyed by a natural disaster or by faulty engineering design. Before I go on, I want to thank both those who are proponents or opponents are going to testify here behind me in case they leave before we finish for being in here today. I had an opportunity to listen to a lot this afternoon, so maybe it's a little educational for some of them. So thank you for coming in. I appreciate that. Many counties around the state lack either the necessary funds or staffing to rebuild approaches to highways. Let me explain what happened in my district. In the 2019 flood, Highway 15 north of the Platte River was completely washed out. It was gone. The road was gone. The roadway was rebuilt to include the intersection at the approach at Highway 15 and County Road C. The same intersection approach was then completely washed away last spring, and you have a picture of the approach in the highway that I handed out. Both the Colfax County Highway Superintendent and I contacted the Department of Transportation to ask for the approach to be rebuilt since it was just completed, I'd say within a year and a half. And obviously was not built to handle the water flow of the ditch. Their response was, no, that it is the county's responsibility. And I will say that they did use, I think there was Attorney General's opinion on that said that that's the county's responsibility. Subsequently, in a meeting with the Director Selmer, it's one of the first meetings I had with him, I showed him and the Deputy Director pictures, same pictures I'm showing you of the damage, and I was told, I believe by the Deputy Director, and my LA can attest to this, that they normally replace approaches that are completely destroyed in this fashion. However, DOT refused to rebuild this approach. More recently, I was told that DOT does not want to pay for the construction of such projects to protect the taxpayer from costs they were not responsible for. So what I am hearing is the DOT would rather have the county attempt to construct an approach that they may not have the expertise to complete, resulting in a hazardous condition on a highway, instead of doing the construction and filing a claim of negligence on the offending party, or applying for federal funds or other funds that are available. The department has stated this does not occur very often. Again, the department has stated this does not occur very often, so I question if safety is a real concern of DOT or just their bottom dollar. The taxpayer pays for this one way or the other, unless there was negligence. I can tell you I am concerned for the safety of the citizens of my district and the citizens of the state. LB 913 would provide much needed assistance to county highway departments in these uncommon occurrences, ensuring proper construction and the replacement of destroyed approaches. I ask for you to move the bill to general file, and I will answer any questions you may have.
Thank you, Senator Bosselman. Any questions from the committee? Seeing none?
I'll abstain.
Thank you. Proponents for LB 913.
Chairman Friesen, members of the Transportation and Telecommunications Committee, good afternoon, almost evening. My name is John Cannon, Joncannon. I'm the Executive Director of the Nebraska Association of County Officials. You may have also heard of us described as NACO. I'm here to testify as a proponent on Legislative Bill 913. First, thanks to Senator Bosselman for bringing this bill before the committee. We certainly appreciate it. I think he described the situation very aptly. At the bottom line, it's a safety issue, but I'd like to also describe some of the other ways that it affects county government. You will have handed out to you some letters from the Saunders County Highway Superintendent and the Chairman of the Board, a letter from the Seward County Highway Superintendent, and a letter from the Knuckles County Roads Department. This is an issue that's been around since I started with NACO. With each passing year, it gets to be a little bit longer tenure. It's important enough that elected and appointed county officials behind me have waited throughout the entirety of this afternoon's testimony. I certainly hope you would indulge them and ask them all the necessary questions that you need to get from them so you've got a complete record in order to make a decision on this particular issue. As Senator Bosselman said, there's an Attorney General's opinion that the state is not responsible for these approaches. That was written a couple of years ago. It was certainly, it highlights the fact that there's a bit of ambiguity in our statutory scheme. This bill would correct that ambiguity and delineate exactly whose responsibility that is. The question is, who bears the responsibility? If it is the state, then these approaches are going to be paid for through monies from our general fund. If it is the county, it is paid for with property tax dollars. Now, I've heard in the rotunda and various other places so far this session, well, the counties have a lot of extra money that you're receiving from ARPA. Same can be said for the state, certainly. But also, one thing I'd like to remind the committee of is that in the property tax context, and I'll just make up numbers here, if a county has an overall property tax asking of $2 million in 1 year and they pay that down by $500,000 because they have ARPA funds, they're only allowed to levy an extra 2.5% or 3.5% through supermajority vote of the board over that prior year's property tax asking. And so if it were as simple as that we could just use property tax dollars to fix all of our approaches across the state, we would be telling our boards that you have to start off behind in the oncoming year. And that is overall from a reliability and from a consistency standpoint, that's poor tax policy. We think this bill is a good start. We certainly value our partnership with the Department of Transportation. They've been great stewards of the taxpayers' money. They have great expertise that we rely on in a number of different ways. But this is something where, because of the ambiguity, it would be helpful if this committee could help clarify that. With that, I'd be happy to take any questions the committee may have. Thank you very much.
Thank you. Any questions from the committee?
I'm going to ask.
They're all right.
Just one quick one. Okay, since you're head of NACO and they come to you with the problems, because I was in their shoes at one time. If there's an agreement between the county and the state, it shouldn't be something we would have to write a bill for. But these are extenuating circumstances in just these 3 areas, or do we have more people that are feeling the same way?
As far as how we handle the construction of approaches in our state, generally speaking, ma'am, the Department of Transportation, through the Attorney General opinion that's been referenced, has taken the position that any of the highway approaches to the state highway system are a responsibility of the counties. They are not a responsibility of the states. There certainly could be other instances where it would be outside of an extreme weather event or faulty engineering. I've not been asked that question. Well, you're asking me that question, so I'll answer it as best I can. My expectation is that the Department of Transportation in all likelihood would say that is not their responsibility, and that would fall onto the property taxpayers.
Thank you.
Yes, ma'am.
Thank you, Senator Albright. Any other questions from the committee? Seeing none, thank you for your testimony.
Thank you very much.
Other proponents?
Good evening, Senators. Scott Hubbard, SCOTT-HUPPERT. I'm here for this bill. I approve. I'm with Dodge County. Dodge County has approximately 55 miles of freeways and expressways, plus 45 miles of 2-lane state highways going through its county, which totals approximately 100 miles of highways. Currently, and another 20 miles of expressways is going to be added into my county already. We are aware of the need for the expressways and are fully supporting of them. However, for Dodge County to be able to work in these approaches for traffic running speeds of 70 to 75 miles an hour, 4 lanes, it would be necessary for Dodge County to shut these lanes down. For me to shut these lanes down, I'd have to rent arrow boards, cones, signs, obtain appropriate permits, have to get an engineer to assess these roads and these structures. This is going to cost the counties a significant amount of money in these projects, therefore adding to the strain of our already struggling budgets for these counties are facing. These counties are not equipped and trained to work in these conditions. As a highway superintendent for Dodge County, I cannot and I will not allow my employees to be out there in these conditions and place them in more stress, or my counties in more stress of their budgets. These approaches were designed, built, and overseen by the state in the state right-of-way, and built with no or very little traffic at that time. Why is the state trying to force the counties to work in the right-of-way and in these conditions? As a county highway superintendent, I thought the state was there to provide assistance to us and work together for the safety of the traveling public. As you know, Dodge County was devastated with the flood in 2019, which destroyed many roads, bridges, levees, in which we are still trying to recover from. The catastrophic total over $20 million. Our budget is significantly strained, therefore Dodge County is in support of amending this bill. I wanted to give you an example. If we were taken over, Dodge County has approximately 96,300 culverts to deal with already. We have 320 bridges to deal with in our county. Our culvert budget is only $60,000. My expense for the budget 2021 was $120,000. The culverts ranging from 18-inch to 144-inch to box culverts I have. The culvert increase right now, which I'm assessing, just jumped up from $22 to $67 per foot for culverts. For an example, a 36-inch culvert, which was costing me $34.46, is now costing me $52.46 per foot. So Dodge County has, if we took these over, we'll have 218 approaches that connect the state highway, and the state will be adding another 34 approaches in the next year, making a total of 252 more approaches that I'm going to be having to take care of. So an average cost, I just figured here, of a 36-inch culvert, 60 foot long, it's going to be with the total of the culvert costs, the surveys, the engineers, the inspection, the traffic control boards, the equipment, the trucking, the labor. It's going to be, just for a 36-inch culvert, $10,108. It's crazy to put it on the taxpayers of a local when it's in, these approaches are in the right-of-way of the state. Go ahead.
Thank you, Mr. Epper. Any questions from the committee? Senator Albright.
Sorry, are you just talking about, excuse me, I just walked out, came back in. Are you just talking about the new roads that they're putting on? The new
I'm talking about all of them.
expressways, or are you talking about any of the culverts that you need to put in anywhere?
No,
You're just
I'm talking
the
about state highways.
Because you're responsible for the approaches to
They're
your
making us
county
responsible
roads.
for them, yes,
Okay.
Senator.
Thank you.
Thank you, Senator Albright. Any other questions? So do you have any examples where you have had to pay for an approach?
Yeah, in the flood of I don't have an example here, but in the flood of 2019, we replaced 3 of them on the state highway because they wouldn't help us with it. The FEMA did help us with it after fighting with the feds about whose right away it was, because we had to pay for them because the state wouldn't. And then the FEMA says, no, that's state right away. Why are you fixing in the state right away? They should have been the ones to file for that. And we argued and argued. They finally said that they would pay for them.
So did you get like a 90% reimbursement?
We got, yes, 90%, yes.
Okay, thank you. Seeing no other questions, thank you for your testimony. Any other proponents?
Good afternoon, Chairman Friesman, everybody out there. I'm Justin Longklaus, GIUSTIN. LaudenKlos. I am the newly appointed Colfax County Commissioner, Superintendent, and Senator Bosman took care of kind of what I was going to talk about down there with the state. He did a good job explaining that, so I'll make this pretty short. That ended up costing the county just $20,000, and that was one of the smaller ones with just a couple 24-inch tubes. We have several other ones with box culverts in it where that would range, if that would ever happen, up to $300,000. And we're just a small county. I don't have a lot of guys. We have 15 guys. It's hard to put us out on the state highway to do that stuff. So it's a real strain on us to take all our guys off to do these projects instead of blading roads and that. So that's all I wanted to get to you guys.
Okay, thank you for your testimony. Any questions from the committee? Seeing none, thank you. Any other proponents for LB 913?
Good evening. My name is Chris Rauner, CHRISRAUNER, and I'm the Pawnee County Highway Superintendent. I am for this bill because we have like 100, at least 100. I think I counted around 100 intersections with the state highway system. We have a very, there's quite a few paved returns. We have quite a few that are unpaved. And we are being told that that's something we have to maintain all the way to the edge of the road. Well, that's okay. Our insurance company doesn't like us doing that, for one, because there's liability issues because you're actually in the state right away. And that's I guess our biggest issue with it. I think this bill does clear up a lot of the language as far as the definition goes of whose is whose. But to me, there's no clear line in the sand. The state actually owns that right away. Why is the county having to do anything inside of that owned right away? So I don't really have anything else. I just wanted to show our support from Pawnee County.
Okay, thank you for your testimony. Any questions from the committee? Seeing none.
Thank you.
Any other proponents?
Good evening, Senators. I'm Matt Shart, MATTSCHAARDT, and I am for, Johnson County. I'm the Highway Superintendent. Pretty much everything these guys just said, I'm for this bill. It is a big safety issue for us. Like Pawnee County Superintendent said with the insurance, it's a big liability for us to be out there. I only have a shop of 12 guys. My guys are trained, and they're trained very good. We are not trained to be along the highway. My guys express fear almost to be out along the highway. I don't want uncomfortable people out there. Another thing is, we get a lot of phone calls daily, weekly about people complaining about stuff inside the right of way. And it's just, there's no answers. My commissioners have told me to try to stay out of that. We have tried to go out there every once in a while to help. If we try to stay certain footage off the highway to make that better for our people in the county. It's getting very difficult. We have, as Johnson County, we have had the Department of Roads, Department of Transportation, in our courthouse to discuss this. And again, it came back to the Attorney General's, ruling on that. So we have reached out to the Department of Transportation. We've had them in our courthouse. We've had other commissioners from other counties there. I've had some of these guys behind me at that same meeting. And we pretty much at that point just shook hands and agreed to disagree on this policy. So that's all I got. I am for the bill. I just wanted to say my 2 words. Thank you.
Thank you, Mr. Sharp. Any questions from the committee? Seeing none, thank you for coming. Any other proponents? LB 913.
Good afternoon. My name is Mark Manelli, MARKMAINELLI. I'm president of Manelli Wagner and Associates. We're a consulting engineering firm in Norfolk and in Lincoln here. We act as the highway superintendent in several counties, including Stanton and Platte County. I want to take a step back a little bit at where some of this came from. I've been working in the transportation business since the 80s. which makes me feel a little old nowadays. But historically, the DOT would take care of the infrastructure on their right of way. When these guys are talking about returns, we're talking about that paved section when you turn off the highway and it's asphalt or concrete and then it turns to gravel and off we go. Historically, the county would take care of everything that hit their right of way or at the end of that paved return. And the state maintenance, or when they would do projects, they would come through and take care of that paved return section. What happened several years ago is a policy was written by the DOT that said, we're not going to take care of those returns anymore, counties. We want you to take care of everything a foot beyond that return. Now, we stop and we say, okay, well, what's the big deal? Pushing snow, most counties accept that responsibility. Adding gravel and rock to the end of those returns, we accept that responsibility. The issue is asphalt typically lasts about 10 years before it needs some kind of maintenance, and its service life is typically 20 years. Now, all of a sudden, I got this little spot of asphalt at the end of the state return in a lot of counties like Stanton that literally has no maintenance abilities to do pavement. Colfax County's in the same boat, so are Pawnee and Nemaha and several other counties that we address. So we don't have the staff or the ability to go do it. So that means I got to hire somebody. I got to hire a big asphalt team to come in and do a little spot of asphalt that would fit in your chambers. Talking with the asphalt guys, if I don't have a project going right there to fix it, it could cost us $10,000 or more to mobilize somebody, come in, tear up that old return, lay it back down because it's such a small amount of work. These returns don't all go bad at the same time. So if Stanton County has 100 of them and Platte County has 150 of these, and we choose to do 5 or 10 of these a year and we don't have any asphalt in the area, now I'm mobilizing an asphalt company or begging them to come in to help us with these costs. Over a period of 10 or 20 years, you could be talking an average of $3 million amortized over a 20-year period life cycle of this asphalt work. Scott talked about his structures. He talked about his culverts and bridges. I'm not even looking at those. I'm just looking at the potholes at those returns. The big issue that started brewing is when the state wrote their policy, the statute isn't clear enough of who is responsible for that area. The counties want to know who's responsible for that area. If it's the counties, put it in the statute, make it clear. I can go back to my constituents and raise the mill levy and say that your mills are going to go fix the asphalt next to the highway. That's fine. Right now, we're working in the state right away. Often, based on the district, I got to get permits, I get permissions, I got to do flagging. It's a dangerous situation. We're just asking for clarification, and that's when Senator Bosselman got involved. And it really came to a head with these disasters. Who's responsible to fix these things? Not only the ones that got destroyed in the floods and the disasters, but in general.
Okay. Thank you for your testimony. Senator Kavanaugh.
Thank you. Do you know what year they made that change? The department?
It's been about 5 years, between 5 and 10 years that policy has been out there.
Thank you.
Thank you, Senator Kavanaugh. Any other questions? Seeing none, thank you for your testimony.
Thank you.
Any other proponents? Seeing none, anyone wish to testify in opposition? Seeing none, anyone wish to testify in a neutral capacity?
Trying to start off good this year.
Welcome, Director.
Thank you. Good afternoon. I think it's getting into evening now. Chairman Friesen and members of the Transportation and Telecommunications Committee. My name is John Selmer, Johnselmer, and I'm the Director, State Engineer of the Nebraska Department of Transportation. I'm here today to offer a neutral testimony on LB 913. LB 913 is written would shift the responsibility of maintaining a small portion of the approach of a county-owned road to a state highway from the county to the Nebraska Department of Transportation under 2 specific circumstances. Currently, Nebraska Revised Statute, Chapter 39, 2105, places jurisdictional responsibility upon counties for the design, construction, reconstruction, maintenance, and operation of all roads with various classifications under the rural highway category. Nebraska Department of Transportation and the Attorney General have interpreted this and other statutes to mean that although a county road may sit upon a portion of the state's highway right-of-way, such facility is still the responsibility of the county. NDOT has simply permitted the county to occupy its right-of-way at that location. I've also included the Attorney General's opinion 20-002 for your information. LB 913 would create a limited exception to this rule by requiring NDOT to design, construct, reconstruct a portion of the county road which occupies the state right-of-ways if it has become unusable due to either an extreme weather event or where there has been, quote, faulty engineering. The bill raises a few questions surrounding the term faulty engineering that NDOT believes would be answered by inserting clearer definitions into the law that can be understood by all. Different people may have different interpretations of what faulty engineering means, and without a clear definition, it is likely that legal disputes could arise over this provision. Additionally, the bill should provide more clarity regarding which entity is responsible for the faulty engineering. If NDOT designed and constructed the highway approach, it should surely take responsibility under the provisions of this bill. However, if faulty engineering occurred due to the county or a third party, NDOT should not be expected to cover the cost to perform the work for that damage that occurred due to no fault of its own. MDOT recommends that subsection 2 of section 3 be amended to clarify which entity is responsible if the facility fails due to faulty engineering. In closing, NDOT and its district engineers encourage our crews to work with and communicate with county and city personnel when delivering a project. NDOT often performs work and collaborates with city and county crews when work needs to be completed if we're in the area. It's good business to communicate and coordinate with our peers, and we want to be helpful. And with that, I probably want to add some more since I've heard some testimony here. As an agency, we're not in disagreement in terms of working with the county to address these circumstances. But I think we heard some broader concerns in terms of right-of-way and who's responsible. And our right-of-way can go tens, if not 100 feet beyond where the roadway edge is. So who is responsible for that? And part of that, I think the prior testimony looking at, I think it's reasonable for the county to do the gravel up to where the approach is. I believe it's agreeable for us to take care of the asphalt that matches up to there and even look at those drainage structures. We want to perpetuate drainage. I think some of our concerns is really what is the right amount of what to do there. We definitely don't want to do snow removal on the county road system just for those segments, similar to where they don't want to do asphalt for a small portion. You know, snow removal would be significant. I understand there's risk with high-speed expressways, but if I give you a simple example of, let's say there's an intersection every mile, and it takes us, we go 30 miles per hour in a storm. It takes us 2 minutes to clear that highway. How much time do you think, at least in one direction, it would take us to clear each intersection? If it took 2 minutes, we'd be doubling our time to clear highways. So does it make sense for us to take on? So I think there's some questions, some dialogue we can continue to have with our partners in terms of really what makes sense. I know in Iowa, when I was there, basically the counties would take care of the gravel. We don't have lots of gravel, and it doesn't make sense for us to go out there and work and try and address what's in the 50 feet or so that we're doing. It makes sense. And I think what Nebraska has done is good. It works. And there needs to be some tweaks. And we want to partner. And I'm not aware of the policy 5 years ago, or whether it was a practice or an agreement, but that's something we will definitely revisit and look at that. We too want to serve the citizens of Nebraska and be effective.
Thank you, Director Selmer. Senator Geist.
Yeah, just a quick question. Neither here nor there really, other than I'm just curious. When you go in to do a repair like this, do you have to do all the the environmental studies to do a repair like you do
Not typically, you know, the only time that really kicks in is if we're acquiring more property, or all of a sudden we find out maybe there's migratory birds or something, or
Okay.
something odd can
Only if
happen
something's
then.
changed.
But typically, if we're doing work within our existing right of way, something like that, NEPA doesn't kick in.
Okay, thank you.
Thank you, sir, guys. Senator DeBoer.
So if I'm hearing you correct, Director, thank you, by the way, for being here. It sounds like you're willing to sort of have joint custody over these approaches so that there would be, that maybe they would do the snow plowing and you would do the asphalt or something like that. Is that what I'm hearing?
No, typically, you know, my understanding, talking with my deputies, is that we were tending to do that, or if we went through a project, we would take care of those asphalt approaches, or we would work it in such a way that it wouldn't be an issue for our county partners. You know, I've only been here less than a year, so this is something I'll definitely dig in. But yeah, I think I think we both look at times at things at extremes, and we're worried about that. I think communication is the best way in which to address that and look at it.
Okay, thank you.
Thank you, Senator DeBoer. Seeing no other questions, thank you for your testimony.
Thank you.
Any others wish to testify in neutral capacity? Seeing none, Senator Bosman, wish to close. We do have one letter in support, that'll be 913.
Thank you, Chairman Friesen. Thank you for the committee for your attention at this hour, and for those, again, who come in and testify. If you look on the back of that, the handout that I gave you, when we talk about the approach, it's that concrete, when you pull up on the county road, it's that concrete with the culvert underneath it all the way out to the shoulder of the road. This washout went all the way out to the highway. It's a 4-lane highway. What you heard from our county supervisors and from county engineer representative was, our counties don't have the expertise nor the person power to do this type of work. And I've heard 3 or 4 different responses to having the state come in and help them fix this. And I believe in Colfax County and highway superintendent, correct me if I'm wrong, the last I knew, they had to have the state come out and actually do traffic control for them because they didn't have the personnel or the expertise to be able to do that. So they're kind of flying by the seat of their pants in a sense. This is a state highway. This is a contract that the state approved. Engineering that was a responsibility of the state. If it failed, as in this case, from a high water, I think it's the state's responsibility to come in and fix it, replace it. It shouldn't be left up to the county. Again, it comes back to the state was responsible for putting the highway in. The state was responsible for putting in the approach in. If it was done wrong, if there's some fault in there, engineering wise, well then whoever was at fault should be responsible, should have to pay for it. But the state should fix it. And then turn around and file a claim accordingly or charge accordingly. We've heard from our county folks. This is an issue that they struggle with. And I think there's not a lot of these occurrences that happen in the state that it's not reasonable. It's not unreasonable. Well, I say it's not unreasonable for the state to pick this up and take charge of this and do what's right. So with that, I'll close with testimony with the bill and take any other questions you may have.
Thank you, Senator Bosman. Senator Moore.
Don't you have any pull with the committee to get this earlier on the agenda?
I wish I could, I actually had a doctor's appointment I had to cancel, so. Anyway.
Thank you, Senator Moore. Senator Albright.
I want to thank everybody for coming because I know they came a long way and they sat through a full afternoon of this. But I will tell you, there's a new sheriff in town and I think he's easy enough to work with to offer up what he did today. So I'm hoping that we don't have to legislate this, that we can work through the department.
Senator Albright.
If I may, the DOT has reached out a couple times. We just haven't come to agreeable language. So perhaps after this, so we can come to some agreeable language, we can make some things work. So,
Thank you for bringing it.
Okay, thank you, everyone. And with that, we'll close the hearing on LB 913 and we'll close the hearings for the day.